days in filing the restoration application, my lord.
That we'll see.
My lord, the honorable bench had directed me to before the ensuing puja vacations. It was listed last year, my lord, and due to the ensuing puja vacations, my lord, I did not realize that there was a peremptory order for dismissal unless the second copy was filed, and for that reason, my lord, the petition was accordingly dismissed, for which I have filed this restoration, and there was a delay of 170 days in filing the restoration, my lord.
WPC number 33598 of 2023 stood dismissed for default for non-compliance of a preemptory order dated 18/10/2023.
Transport, Mr. Behra.
Who is for? Have you served
Mr.
a
Behra,
copy?
Prabhakar Behra.
Will inform him.
Will inform.
Do you have any objection?
Whether he has submitted the copy of the to the standing council or not, that is a question.
Transport.
I have.
Have you
served?
informed
You have served?
him?
My
Have you
lord,
served a copy?
my lord, I'll serve a copy, my lord. I haven't served. As per my knowledge, as of now, I haven't served.
Application has been
My lord,
filed.
my lord, it has been served. Extremely sorry. It has been served to the standing council, my lord. Standing council transfer.
A copy of the this application has been filed for a restoration of said writ application to its original file and for a recall original file. Have you complied with?
My lord, I have complied with. I have filed the second copy, my lord.
Current counsel appearing on behalf of the petitioner has submitted that of the present application for restoration has been served on Mr. Behra, Learned Counsel, who represents the Transport Department. Transport Department?
My lord. Standing council transport, my lord.
Standing council transport.
Standing Council Transport. There is an application filed for condonation of delay in filing the application for restoration of the writ petition. Stopped. It has been held in case of so and so that an application for restoration of a writ application filed under Article 226 of the Constitution of India cannot be treated to be time barred, though delay and latches can be considered while restoring while passing an order for restoration. Stop. The counsel appearing on behalf of the petitioner has submitted that she was unaware about the fact that the order dated 18/10, that out of mistake she could not appreciate that the order dated 18/10/2023 was preemptory in nature. So when did you file
My
second
lord.
copy?
The second copy? I filed on December, my lord. I don't have the exact date. I filed it in December. I'll just.
The second copy of the writ petition as was directed by this court by order dated 18/10/2023 was filed. Do you have any idea?
My lord, I filed it just after the puja vacations. I'll just provide the date. Sure.
Like,
Within-
soon after reopened upon after puja holidays, No problem. Next, considering the facts and circumstances and submission advanced on behalf of the petitioner as noted above, in the interest of justice, this application is allowed. Let WPC number so and so be restored to its original file. IA number so and so, 175 of 2024 stands disposed of. Yes.
Have you touched?
At the fag end of my career, of 48 years of my practice, I've never seen such decadence in the judicial adjudicating process. In court number 10.
Please don't do that.
Why I say so,
Please,
my lord.
we are warning you. Don't say that.
Why I say so, my lords. He refused to hear me
Please,
and categorically stated, my lords,
please.
I will not hear you.
Please, call the case. Give your slips.
I've given it in writing, my lords.
For orders.
Out of late, tribunal appeal में bail आ जाता है, apply में shift के appeal में रहता है.
Please give your slips. More than?
Custody, since the elder bail appeal rejected.
All right. It will be listed.
I may be pardoned, my lord.
Pardon, my lord. My lord, this is a memo for withdrawal, which is not being listed for the reason that the original writ petition was dismissed by Honorable Justice R.K. Patnaik and Honorable ex-Chief Justice. My lord, for that I had filed one CMAPL. Now, my lord, it's pending since 2023. I have to withdraw it.
Give.
My lord, I may be pardoned, my lord.
Give your slips. All the slips.
This covered matter, my lord, by lordship judgment, my lord.
Please give.
My lord, I may be pardoned, my lord. My lord, in obedience to my lord's
Yes,
yes.
Yes,
My lord, in
I cannot
45,
forget your face.
my lord, in 45, I humbly pray the matter may be taken up day after tomorrow on
You
26.
wanted the matter to be taken up today.
My lord, all right.
Pardon, Lordship, this is a tender matter, my lord.
Students of stipend matter, my lord, maybe taken tomorrow at 2
Please give your slip.
My lords, this is a tender matter, my lords. This is an urgent
Please
situation.
give Mr. Counsel your slips.
Beg your pardon, Your Lordship. Only because Your Lordship will not pressing the challenging
Please.
the ultra vires, Your Lordship. Matter will be-
Have you mentioned that in your?
Yes.
I see everything.
May I please your lord? My lord, item 60, sub item 3 permitted to withdraw.
No.
My lord, should I wait, my lord?
No. Give your slip. Please slip.
Items 42 in the list, the Lordship board, my lord. Yesterday it was mentioned. Can it be taken up?
matter.
Tender matter.
has been
Can it be today?
us are mentioning, my lord, any time, your lordship. Can be taken up.
This is an urgent demolition.
We'll see what can be.
Because the 2 o'clock some matters are there, already fixed.
2 o'clock, I have a judgment.
And 4 matters are there also mentioned, already there in the list.
All right. So first of all, that will take hardly for 30, 45
After that, if
minutes.
time permits, there are
The judgment matter is at 3:30.
We have to deliver 2 judgments. One at 2 and the other at 3.
tomorrow first case,
Tomorrow, just make a mention, we will take up.
right?
Tomorrow,
Wednesday.
Thursday, first half we are available. Just make a mention, we will see.
Right.
Just inform all the parties.
Three of us are there.
How long will that take?
Right. Tomorrow we'll make a
No,
mention.
we there. All 3 are for the petitioners.
No. We are
No,
all,
I am for
All
the
right,
petitioner.
all of you are fighting.
3 of
All-
us, there's a joint mention by the 3 of us.
All right.
Tomorrow first of all.
Tomorrow, just make a mention in the
Right.
morning, we
Great.
may take up.
Which is that item?
Item 42.
All right.
My lord, in 45, it will be taken up today, my lord.
45, you wanted
Yeah,
it to be taken up there after on Thursday.
Last week I had mentioned of the demolition matter. Demolition is going to have.
Please give your slip.
I may be pardoned.
Just ensure that what you mention in the mention slip.
I may be pardoned to mention, my lord. I may be pardoned to mention all the nursing matters. The time has been extended up to 30th of October by the INC.
I will make a match case in the original case, but I want that because I am not well prepared for that mental agony. So let it be all the matters be listed on 1st of
What happened?
October at 2 o'clock.
Is there any bereavement in your family?
Yes, my lord. That's why I took leave on that day. Yesterday, my junior's mother also died. So both the cities came, so I couldn't do anything. So let it come on 1st of October. All these matters at 2 o'clock. So that will be cover up.
The
I have given the list. Okay, I have
item
given the
number
list.
40.
46. I have given the list, my lord, to him.
All right, slip. Order.
For orders, item number 24.
20. So if I may please your lordships, my lord. My lord, this is an application for recall of the order dated 2/11 of this honorable court on the ground that the present applicant
Item number
24.
The other side here.
My lord.
So how can this application you have filed?
You file power on behalf of the appellant.
No, my lord. My lord, I have filed
Respondent.
my lord, I have filed an application for intervention that is there.
No, because your name doesn't show on the right
No,
side.
my lord,
there is
I am
something on
not the
left side.
respondent. I am not the appellant.
Oh.
I am a party. I am the second wife of the deceased husband.
So how can you file a recall of the order?
My lord,
You
I
can-
filed an intervention application as well.
Intervention in a disposed of case.
No, whether this matter is pending,
This has
no,
been
disposed
disposed of in my absence.
then you can file a review. You can file whatever you want.
My lord, may kindly appreciate for a moment, my lord. My lord, I was
Sorry,
not made.
IA, not interlocutory application. And when the matter is, see, what is the meaning of interlocutory?
My lord,
What is the meaning of interlocutory? Just tell us.
my lord, I am seeking a recall of the order.
A recall of the order. How can you file interlocutory application? You can file an application for correction of some typographical error or clerical error. But how can you file an application in a disposed of matter for recall of the order? If the order is bad, you can challenge that. If your order is bad, you can file an application for review. But how can you file IA?
My lord, in the absence of me being a party, I cannot file a review application, unfortunately.
You cannot file a review application.
Because I was not
Very
made.
difficult.
My lord, I kindly appreciate. My lord, because I was not made a party, dehost the fact that I had married my previous the applicant wife's daughter was already as a party.
Sorry.
My lord,
Application. IA number 31.
31, my lord, I've also filed an application for intervention, my lord.
This application. What is this? The matter is disposed of and you are filing an application for intervention.
My lord, after my lord,
Mr. Counsel, an order may be illegal, an order may be incompetent, an order may be authorized, but there is a procedure to challenge that. IA number 31 of 2024 right, for the recall of an order dated. What is the order?
2/11/2022.
2/11/2022 passed in MATA number 13 of 2020. So stop. By the said order, MATA 13 of 2020 has been disposed of. Stop. The present application for a recall of the order has been filed on the ground that the petitioner was not impleaded as party. Stop. According to Inland Counsel appearing on behalf of the petitioner has submitted that the applicant is wife.
The second wife
Is the second wife of
the deceased husband, original respondent.
of the deceased husband, who was original respondent, MATA 13 of 2020, and the said order has been passed in her absence. First off, in our considered view, this interlocutory application filed after disposal of MATA number 13 of 2020 cannot be entertained on the grounds for the purpose as noted above. So this application is thoroughly misconceived and stands dismissed.
My lord, may I kindly take the liberty to file proper application if your lordship can
It will
kindly.
be open for the petitioner to pursue such legal remedy against the order of this court dated so and so, which so and so as may be available to her under the law.
Gratefully.
Not 25.
Item 25, item 25, we have appearing for the NTPC. Item 25, we are appearing for the NTPC.
Or
Item 25, Lord, we are appearing for the opposite party number 1 in this writ appeal. Lordship, I will received a copy on last
condonation of delay. What is the delay?
My lord, yesterday this matter was there, your lordship asked me that when your previous writ application was dismissed, for which you are delayed by the, because the application was dismissed due to the wrong prayer. My lord, in this regard, I have.
No, your writ appeal was dismissed.
Yes, I could not file the previous dismissal order of the previous writ application. I have opted for it.
Yeah. Effective prayer. Where is that order? It has been listed along with that. No. Have you annexed the order in the previous writ appeal?
No, that's why I am filing today.
This is the previous writ appeal.
Yes, writ application I have mentioned, but I am
Completely
right.
misconstrued.
But the previous writ
So that
application.
cannot be restored. So reason has been assigned. It is not a case of this.
Wrong prayer, my lord.
Okay.
So what is prayer?
Prayer is to modify the order.
No.
Because
What was the order in the, what had you challenged in the writ appeal?
in the
What was the prayer in your previous writ appeal?
previous writ application, I had prayed that when the order was passed,
No.
page 29 of my writ application, may kindly see of this writ application, page 29.
That is the
So
writ
where is
appeal.
this order? 9/3/2023.
2033.
That is at page number 36. That is annexure 6. Start from 34. Page number 34, annexure 6.
36. 36.
So you can challenge the order.
Yes.
Not restored.
Street appeal.
It is first writ application.
Yes.
For OP number 1, we have already received the copy. Because last week he has served the copy to us. Lordship, grant me 2 weeks time so that we
What
can.
is the delay?
Delay will explain in a.
Then we'll condone the delay.
We are
We
condoning
will
it.
file a short reply to the
What
condonation
reply?
of delay because it's
What
the
is the delay?
delay if your lordship will see it about 9 months delay, near about 7 months delay. So,
5
your
year
lordship
objection.
just give me 2 weeks time, we will
Going to
file a
accept
reply
notice.
to delay bill.
All right.
Because it is a corporate beneficial.
Going to accept notice on behalf of the respondent number,
OP number 1.
OP number 1. He seeks adjournment to file an objection to petition seeking condonation of delay. Stop. Discuss matter 2 weeks.
Item 26. Item number 26.
Yes.
26 for your lordship issued notice. It is there, in fact, your lordship says, if there is service, then there will be substantial representation.
Where is the order of?
If your lordship looks at the order dated 13/8 and 2/9/20, sorry, I'm sorry. 13/8.
No, but what is your explanation that you filed this restoration?
Sir,
application?
actually, the counsel senior advocate was there, his office was there. He died in COVID. So as a result of which, no information was given to anybody else. After he came to know, he approached in the office, nobody was there, and therefore he contacted one of the junior counsel, and he handed over the file, and then he came to know that all these things have happened. That's the reason why he has filed.
No, but you cannot explain 5 years,
But actually,
2018.
delay was because the file was there with the counsel. What should we kindly visualize? The client was waiting for the response from the advocate. He was not heard, therefore he contacted him. After he came and contacted, heard that he has expired, in fact. And all the office file, they should have been informed, in fact. The law requires that somebody office is closed, they must inform all the clients to take back the file. No information was given. So he doesn't have a fault as such of the role.
And what is the matter about?
Matter regarding partition, actually, the share has been allotted in favor of somebody else who is not deserving it. My share was granted in favor of my favor. And that was again subdivided. That means my homestead land will be divided again.
Restoration
valuable
of
property.
HO. HO has been dismissed in 2018.
Yes,
What,
madam.
what COVID then? What are you saying about COVID? COVID?
But COVID, actually, if you also looks at Justice Mr. Mahapatra, Ashok Mahapatra,
Yes, yes.
he died in COVID.
Yes.
The file was with him.
File was with him, but the writ petition was dismissed in 2018.
But it was there with the office. Yes.
Bharat 3 months. Bharat 3 regarding the expansion, it was dismissed. Thereafter, the restoration application also dismissed. Bharat 3, they have explained the.
Where is the restoration, dismissal of restoration application?
Kind of look at the restoration application.
Where is the restoration dismissal?
But inner page 7 minute. Paragraph 3, if your lordship looks at. The AHO was listed for hearing on 19/7/2008 before the Honorable High Court. However, none appeared on behalf of the appellant on the said date. The appeal was dismissed for want of prosecution. It is humbly submitted from the counsel, Mr. Ashok Kumar Mahanti, was appearing on behalf of the appellant, inadvertently missed the list. Mahapatra. So it is Mahapatra, not Mahanti, Marad. I'm sorry. It is Ashok Kumar Mahapatra, who appeared on behalf of the appellant, inadvertently missed the list for the case. Didn't appear in the list, therefore couldn't appear on the date fixed. The fact of dismissal was not within his knowledge. It is only in the month of February 20 when the opposite party tried to bring ours in favor of the property of the appellant. Contact his counsel and inquired about the status of his case. Therefore, the counsel of the
No,
appellant.
but what happened after 2018? He's saying that it was restored.
But 2018, the client had no knowledge about it, Bharat. He has to contact the lawyer, Bharat. He contacted the lawyer after the wanted to break the boundary or dig some earth.
So you contacted in 2020.
20.
That is what you have stated in paragraph 7.
Yes.
Counsel for the petitioner.
September 2022.
File an application for restoration.
He died in September 22.
Let us wait, we will not.
But he had no fault, in fact. So, you kindly see.
Yes, he has fault.
If your lordship looks at page 9 also, it's in the
So then you have taken a plea that petitioner number 1 is suffering from neurological
He was also
problem.
he was a
So where is
patient.
that certificate? If you take a medical
Certificate is
down
given
medical,
on
you have
page
to take
8,
a certificate.
page 8 of the application. Page 8, 9. Page 11 also. He was treated by Niranjan Rathamar, Dr. Niranjan.
Yeah, what was the order? HO was filed challenging order for pass and first appeal.
Yes. But homestead property in which I have got share, 1/3 share.
Maybe that is different. Your.
But here actually the difficulty
You
is.
lost in the before the civil court.
No, civil court I own. Appellate court, my property was again divided. I own in the trial court. Suit was decreed. To the extent my share.
Wait for the.
No, he is also there with me. He is appearing for one of the respondents. He also supports one of the. Sorry, he is appearing after the notice, I think, maybe.
So who has not appeared?
Other respondents, number 3 respondents have not.
Well, that is substantial representation is all partition.
No.
How can that be when the delay
No,
is
this
so
is 2018 and.
But then notice has
dismissal
done. No, you have issued notice.
All right, take fresh steps. We are not.
OP6,
The tracking report is there.
OP6 return to sender. Address is not known. So that you have to take 3 and 7. I'm checking. 3 is
OP
delivered.
number 3 to 7, 3 and 7. The tracking report is there. Exhibit flag C and D.
3 and 7 delivered.
3 and 7.
3 and 7 delivered. Was undelivered. I mean, nothing returned. So that one delivered. The OP6 has to take place.
Who is OP6?
Only OP number 6, it has returned the answer.
Yes, who is OP6?
Who is OP6?
OP6 is one of the co-sharer.
And he will have to be.
I'll take notice, madam.
The steps be taken for service of notice upon respondent or opposite party.
Opposite party.
Part number 6. Yes, 1 week.
And are you sure the name of OP6 is correct?
OP number 6, I'll correct the correct address.
No, look at the description.
Correct.
Santosh. Santosh, daughter of Duryodhan Mahanta. So that is why they could not find any such person.
Just 1 second.
Santosh sounds like a man's name and you have not given any such anything. 45 years may have been married. So you check. Otherwise you'll never be able to serve notice.
But Santosh Mahanta, madam.
Whatever, I'm looking at your cause title.
Santosh Mahanta.
No, cause title is Santosh.
He is the son of Duryodhan Mahanta.
Again, son you are saying. In the cause title you have written daughter.
It is there in the.
No wonder notice could not be served.
That are all resident of Jarposi post.
Mr. Misra, you make up your mind whether she is son or daughter.
I'm sorry. Santosh name both male, female.
No, it can be, but unless you describe her properly, she is not going to choose male or female. She will is what she is. So you
I'll
have
check up and take the steps. I'll check.
also correct your cause title also if required.
Yes.
Item 27.
Yes.
Item 27.
In item 27, there is a noting that requisites not filed. Lordship, order dated 6/4/2024. Notice was issued on limitation and also in W writ appeal. Notice was issued and the file notice was also issued. Now, after despite notice that your lordship can find it from 25/6/2024. Despite notice, there is no representation on behalf of the respondent. Thereafter, your lordship allowed that limitation subject to deposit of rupees 10,000 and I have deposited that. Further, there is a noting no requisites has been filed for which notice. If your lordship, I can file it within 3 days.
Have you paid the cost?
Yes, ma'am. I have paid that cost on 22/7/2024.
When is that 432 posted to? Because it was supposed to be tagged with that.
Yes, ma'am. 432
That
was,
is the reason we converted.
it was last listed 2 weeks before, my lord. That has been urgent for 8 weeks after because the similar matter was pending before the Honorable Apex Court.
But here requisites you have not filed.
Notice was earlier issued.
So
Again,
you won't file. On 13/8, there's a specific order that.
I have missed that order.
No,
So
no. It was not earlier filed.
my lord,
Notice had been issued in the matter of limitation, delay had been
and
controlled.
read appeal also.
Writ appeal thereafter notice was issued, you have to file requisites.
Again, I will file. But that on 6
Writ appeal you have not filed requisites at all. So question of again filing does not arise.
on 6/4/2024.
That was in the matter of limitation.
Limitation and read appeal. Again, I will file requisites within 3 days. Plus,
Yes. Both.
in both my lord notice was issued.
Okay.
And I will file within 3 days.
If the
Again,
requisites be filed,
within 1. Within 3 days, I can file.
yes. 6 weeks. Yeah.
Item 28.
6 weeks.
Your Lordship, in the present writ appeal, IA number 5569 of 2024 is filed for condoning the delay of 35 days.
Who is for the other side? Notice was issued.
No, Your Lordship, notice was not issued. A delay has not been condoned. Your Lordship, the appellants have challenged the order that judgment dated 21/5/2024 at annexure 10, Your Lordship.
What is the order?
Lordship, as per the judgment, the respondents who are working as junior teaching assistants in IGIT Sarang have been allowed promotional pay scale to the post of senior teaching assistant with effect from 1996 on the basis of a settlement made in the case of their counterparts working at UC Burla. And in the judgment, it has been held that since both the category of employees are similarly situated, they would be entitled to the consequential benefits.
All right.
May I place the relevant portion of
Just
34 days filing the writ appeal. Notice. All private parties or
Your Lordship,
State is also there.
so for my respondent.
All, issue notice to respondents, issue notice. Notice is on behalf of respondent number 5 is accepted by
Well,
Mr. Suman Patnaik, learned additional government advocate. 1 to 4, within 1 week.
Item 29.
Your Lordship, there is an IA for.
No, not now.
But no delay,
29.
There is 87 days delay. Yes or no? My learned friend is appearing while serving a
who
copy.
is appearing?
Your Lordship.
This one to accept notice.
So, how many days delay?
87 days.
87 days. Will condone the delay?
Your Lordship.
Delay of this IA has been filed. You have appeared today?
Your Lordship. Early filed yesterday. Given the slip.
You're Mr. Mahapatra, SK Mahapatra?
SS Mahapatra.
SS Mahapatra. IA for condonation, this IA has been filed for condoning the delay of 87 days and filing the writ appeal. Mr. SS Mahapatra, learned counsel submits that waiving notice, he has already appeared on behalf of respondent, the sole respondent. Sole respondent yesterday. He accepts notice on waiving notice, he has appeared on behalf of the sole respondent yesterday, full stop. Answering the reasons stated in the IA, we are satisfied that this is a fit case for condoning the delay in filing the writ appeal. The delay is condoned, the IA is accordingly allowed. Writ appeal.
I'll serve in course of the day.
Full stop. Writ appeal so Mr. Leonard, additional government advocate undertakes to serve a copy of the appeal memo on Mr. Mahapatra, learned counsel in course of the day. This is the case for fresh admission.
My lord, your lordship, note I have served.
Copy of the appeal memo is served on Mr. S. Mahapatra in court today. List for fresh admission on 8/10/2024. Yes.
Probably.
Item note 30.
Sir? Yes. May it please my lordship, this matter was heard yesterday. Your lordships had said your lordships will be kind enough to dictate orders today, my lord.
At 2 p.m.
That's what I thought. That's what I thought your lordship dictated. I'm grateful to my lordship. We'll be there at 2. I'm grateful.
My lord, item 27, my learned friend has appeared. For respondent. Lordship directed me to file various notice. I'll serve him in each last permission.
Okay.
Item 27.
Same order as item 29. You have appeared for whom?
Again?
कहाँ पे appear कर जल्दी?
27.
27.
अरे कहाँ पे लगी?
Respondent.
Only respondent.
Respondent पे appear करोगे जो sole respondent ना कहते हैं?
Sole.
अपन नाटा.
Vasudev Bari.
Vasudev Bari. You already filed wakalatnama or will file?
Will file.
And I'll serve in course of the day.
Copy of the appeal memo. So, or will we keep it to 8th, or you're saying it is that Supreme Court case?
Yeah.
Or you give us the date on 8th, we'll keep it to the same date.
Item number 1.
Item 1.
Lord, I appear, my lord, for one of these matters. I think my friend Mr. Subramaniam also appears, my lord, for one of these matters. These matters, my lord, are an offshoot of what happened during the COVID period, relating, my lord, to removal of iron ore after the lease period expired. So there has already been one round. Milord, the High Court by a detailed judgment directed a remand to the authorities to allow, to consider, Milord, whether we can be allowed more time for removal of our iron ore beyond the time prescribed, Milord, by the rules in view of COVID situations, which were emergent situations of a pandemic, which, Milord, our case is based on certain orders passed by the Supreme Court, where the Supreme Court granted, Milord, nearly 1 year's time in 2-3 cases, 4 months, 6 months, 2 months, etc. Our case, Milord, after the remand, the authorities have again decided to refuse any time to us, despite, Milord, the High Court having found that it was a case of force majeure, and the central government had also issued various circulars, Milord, exempting the guidelines. So much so the Supreme Court, your Lordship would recall, had exempted, Milord, the issue of limitation in various matters in High Court and the Supreme Court. So it is our case, Milord, that we should have been granted time, at least on the parity of the Supreme Court, which we ignored. This is, Milord, my case where my lease expired on 31/3/20, and now there is a new lessee in place. So my material has been kept on the side. That new lessee, Milord, has no objection if I remove my material, etc.
Mr. Advocate General was appearing on the last date.
He's not
Yes,
well
Milord, he
today.
appears, Milord.
He's not well
Earlier
today.
it was
Although
Mr.
there was-
Parija. Now I think, Milord, it is another.
No, then last week we think he was appearing for the
on 12/9, on 9, he was there. There was a specific direction that matter will be taken up for hearing today.
Then,
correct.
But he's not well today, so if my learned seniors would continue,
then you will have to seek their consent. The matter was fixed for hearing today, and if you have any difficulty, you should have made a request to them.
Milord, they did not tell us yesterday. We have kept ourselves free from the Supreme Court, Milord, for this case.
That is the whole difficulty. Learned senior counsel has come from Delhi. Other learned senior counsel are there, so you should have informed. The minimum courtesy. This is the requirement of minimum courtesy. Then we can proceed with the hearing. We'll hear learned advocate general later.
That's true. I am ready, Milord, and so would Subramaniam be ready. We can do our cases.
Should we proceed with the, or if they permit you, then only we can adjourn. Otherwise,
Milord, I think we should get along with it.
May I say something, Milord? I
Yes,
think, Milord, the advocate, Milord, if he is indisposed, I think, Milord, we owe it to his office and the dignity of his position that we should accommodate him. I think, Milord, that is what we would be expected to say.
Yes, Mr. Rohtagi.
Milord, after Subramaniam has said it, Milord, I don't want to contradict my learned friend. We are on the same side. I leave it to your Lordship, Milord. I see Harish Malhotra from Delhi. He has come here despite, Milord, that we have, I think, a farewell in the Delhi High Court today for 2 of our judges going to different high courts. He would have preferred to have been there, but anyway.
Milords, I have also come from Delhi, but Milords, whatever senior advocates have said, we have to abide by that.
All right. When?
Any date, a week after, your Lordship.
Week after means let us have
No, here my predicament in the first matter, I am there for the opposite party number 3. On my instance, this first matter was listed on the first date. On the prayer of the Lord Counsel for the prisoner, all these matters have been tagged. But I am the opposite, I am the subsequent lessee. My lease has not been challenged. My predicament is because of these ores which have been stacked in the mining area, and I am not able to operate.
We will hear you, everyone.
So, your Lordship, fix a short date.
Short date. Before holidays, if the matter can be taken up, then.
From 10th onward.
1st October.
1st October.
First week of
1st October.
1st October.
1st October.
Yes, Milord, 1st October is fine. Would your lordship, my lord, consider taking it at 2 p.m.?
All right, we'll take up at 2 p.m.
So that, my lord, we can be free from our work here and there, and
All
we
right.
shall be before your lordship at 2 p.m.
With my due regard, on first, my lords, I have a matter in CLAT. So, my lords, first would not suit me.
You can come at 2 p.m. after completing your.
Anyway, my lord, one of us can start.
Why, yes.
Either I will start.
Do you think that if the argument begins on first, it will end on first?
I don't think so. I don't know.
So therefore,
it may not end.
See, the hearing will continue because of the presence of the eminent counsel. We can understand the complexity of the issue. We can rather guess. So we will hear the matter on day-to-day basis. So if it begins on first, it will continue on second.
Yes, Lord, it will not end.
That
second will be holiday. On third rather, not second. Third.
Second is a holiday, my lord. So third.
So third. So the
That
hearing
would be
will
the best
continue.
course of action.
We start on first, my lord, at 2 p.m.
So let us begin on first, and
yes,
it is submitted on behalf of the estate that an Advocate General who has to address this court is indisposed. So, list this matter on 1/10/2024. How many cases are there? One.
No, there are several cases, my lord.
There are 6 items. These matters on 1/10/2024 to be taken up at 2 p.m.
We are very grateful.
Grateful.
Lord, I have a small prayer. I'm appearing as an intervener in sub-item 3 of item 1, my lord. But we have filed writ petitions challenging the demand made by us because due to non-compliance of section 8B of the MMDRI, there are demands will be taken up together, my lord, so that everything can be heard together.
We will see. See that.
Your lordship may see, my lord, that's a different issue altogether.
You will see that.
It's not the issue there. It is only extension of time that. Thank you, lordship.
Grateful, my lord. Very
Deeply obliged. Deeply.
Right.
Five.
Item number 2.
Your Lordship's filed order dated 10th of September 2024. Your Lordship permitted me on my prayer that the negotiation is going on. Therefore, my Lord, I met the authority. I have given an affidavit, my Lord. I filed an IA, serving a copy to my reverend friend, that the authority, my Lord, the chief engineer, he has assured me that since he is going to Patna in a conference, he will not be available for about 1 or 2 weeks. Then he assured me that within 2 weeks, the matter will be placed before a committee, and committee will take a decision and give intimation to me. That is why, my lords, have filed an application to grant me at least 2 weeks' time, as per the statement given by.
We will grant you time.
My lord?
But we will grant you time. But what is the cost of the flat?
My lord, that will be negotiating because the schedule.
No, just.
I have not.
How much?
You had said something, I think.
What is the
71 lakhs?
They say 71 lakhs.
I have mentioned you are also referred to in the order.
And how much fee you have charged in this case?
I am charging, my lord.
Cost of the flat.
In fact, should I be
more money than
should I be frank, my lord?
No, please.
No,
please.
I should.
Please, it's sir.
No, frank is my lord. Is a relation of mine. No fee.
All right, we withdraw.
I was just going to say that.
All right.
That's the problem.
As requested by Mr. J.K. Rath and Senior Counsel, list this matter on 3 weeks after.
Yes.
Item number 3.
Item 3, my lord.
Yes.
Your lordship has directed order dated 17/9/2000.
Yes.
In the last order, my lord, your lordship has directed the corporation, that is the tender matter, my lord. Your lordship has directed to take instruction whether the corporation is ready and willing to cancel the tender process and go for fresh tender. In fact, I was not well, so I have already talked to the MD. In principle, they have agreed, my lord. So if your lordship can call it on 3rd, my lord, so on 1st, I will file the affidavit. Or my oral instruction is that they are ready, my lord. Beverage Corporation, my lord.
Beverage Corporation.
I am for the petitioner, your lordships will recollect this is the disqualification under challenge. The disqualification was on the ground that there are different trade names.
No, but they are going to cancel.
Your lordships had
Your
directed
lordship's last
that by
order
the
was
last
clear, my
order.
lord. Your lordship's last order, my lord. It is
17
made clear that interim order shall not come on the way of the corporation taking a decision on the point of cancellation of tender process and issuance of fresh tender notice.
So that order, that observation, we were compelled to make because you were saying that because of pendency of the
Cancel
writ
it. I have
petition, you are
oral
not in a
instruction.
position to take it.
Oral instruction is that corporation is ready and willing to cancel and go for fresh tender. Your lordship can record my submission and dispose of my lord.
No, your lordships, let it come, my lord. Let them file an affidavit to that effect. So lordships may take it up thereafter.
Disposing of.
On 3rd, my lord. Your lordship
All
may call
right,
it on 3rd.
Right. Then counsel representing the Beverage Corporation
My lord.
states that the corporation states based on instructions that the corporation, comma, in all likelihood, comma, has likelihood is going to cancel the tender process in question. Therefore, oral instructions. Stop. Place this matter on 3rd.
Interim
So
order.
as to enable him to seek clear instructions and file affidavit if any decision has been taken in
Interim order to continue, my lord.
interim order shall continue.
Great.
Item number 4.
Item number 4, before my lord, senior starts, may make a small submission, my lord. Lordship, in this matter, Senior Advocate Pitambar Acharya is representing National Highway Authority of India. He is not well today. His lordship, I pray for short accommodation only.
But in fact, I have been suffering because of an order of blacklisting slapped on me. And the matter was heard twice, my lord. And with the hope that the matter gets culminated. That is the reason no interim order was passed. I can demonstrate, not if there is an interim order, I will have no problem, my lord. I can demonstrate with this, my lord, that the order of blacklisting is dehorsed, my lord. It's against the.
All right, we will take up your matter on 1st.
But can we do 30th, my
That's the
lord?
first case.
30th, my lord.
30th.
Yes.
All right.
30th, my lord.
30th, Mr. Counsel.
Let it be on first, my lord. I'm not sure. Like, he's not well today. Maybe some viral infection, something, my lord. I'm praying for.
We will try at least on 30th.
Grateful, my lord.
Because 30th it will come as the first case.
Well, I think it will not be inconvenient to Mr. Acharya.
And the first
If it is at 2 o'clock also, then.
first case, you have some objection?
First case at 10.
No, I have no objection because what he says, that is the reason I am saying.
First case. As on the ground of indisposition of an advocate general representing NHA. Mr. Pitambar Senior counsel for the NHA.
Item number 5.
Grateful, my lord.
May I please your lordship, my lord? Madam Pamira, senior counsel, is appearing in these matters, my lord. Item number 5, most of the matters. She is out of station my lord, for some urgent work. Madam, pray for a adjournment any date.
Yes.
Yes, how much? Any means what?
My lord, as per your wisdom.
No, any means after 2 months.
Next week, any day.
Next week, any date, my lord.
Next week, any day.
As requested on behalf of the.
My lord, I may pray one thing. But the interim order, my lord, has detected last occasion. You know, and the portal has not yet been opened, my lord.
What is the interim order? All right, we'll see.
My lord.
Last matter I have, my matter is the last matter, my lord. It is coming first time, my lord. Interim I am praying. Last matter. I am praying for the interim.
Last week.
First time my case is appearing. Last case, my lord.
Last week.
Interim order my kind of.
Another matter, my lord, WPC number 23213, my lord. Not listed, my lord. I have given
To
the
mention.
Yes.
Morning.
Yes, my lord.
Let there be a system. Sort of.
Item number 6.
That reservation matter, they have just served the counter now. They just served the counter now.
Yeah. Then senior counsel appearing on behalf of the petitioner states that a copy of counter affidavit has been served today in court. So he requires to consider the said counter affidavit and if required, advise filing of a rejoinder to the said counter affidavit. So stop. As requested, list this matter on how much time?
Seven days.
Well, I am appealing for the opinion of 5 million on Mr. Palit OJU.
Item number 7.
You are Mr. Misra?
Madam.
On the last occasion, your lordship directed to file counter. Directed to OPs.
Item number, sub item number 2, Sumit Joshi 2103, sorry, my lord, 22307 of 24. We have received copy yesterday, my lord. I request my lord, at which time may kindly allow to file counter in both the matters.
First one, I think long back you have been granted. First one?
First one, I will file the counter by Thursday, my lord.
You're for OP number?
I am for the OP number, OJ, my lord, OP number 4 in both the matters.
So I am for opposite part number 5, my lords. I'll also file counter within this
You have
week.
filed?
No, this week we'll file. We prepared, my lords. Within 2 days we'll file.
My lord, now the OP number 5 not allowing the petitioner to participate in class and preparatory classes for practical examination. So I have filed a IN number 12696 for a direction to the opposite party number 5 to permit the petitioner to continue her classes till disposal of the writ petition.
Thereafter?
Or until further on, petitioner was provisionally selected by the OJE and thereafter took admission. But now the
No, took admission when?
BMS course.
When?
2023, my lord. And said
No, my lords. Lordship may allow this. The students, we are also not
So,
restricted.
but what do you want? Why do you want our order?
My lords, because we have taken admission on the instruction of OJE and the National Council has stopped. So, my lord, that is why we are not able to, because National Council has not allowing us, my lords.
My OJE has admitted to the petitioner as per the OP number 1 and 2 instruction. And they have their own guidelines. We have admitted them according to the guidelines of the OP number 1 and 2. We will file counter, my lord.
Who are you?
We are for the OP number 4 OJE.
OJE is joint examinations.
Sub-item, in sub-item, I have annexed the letter of the OJE mail. As per the OJE direction, the OP number 5 admitted us. Now, I am admitted in 2022 mail. Now they have cancelled.
Well, according to the National Commission for Indian System of Medicine, they have their own guideline. They have instructed to
Who is
us.
appearing for National Commission for Indian Medicine, some council something.
Learned DSGI along with Madam Babita Sahu was appearing. Because I had informed.
Every alternate day, or when do they appear?
The copy has been served on him.
Yes. Miss Babita Sahu filed her appearance. Not in the second case. Second case, have you served copy?
Yes, served copy.
Copy served to yesterday, my lord.
No, not you.
Already sought on 3/9/2024.
3/9/2024. File receipt?
Yes, yes.
Students may be allowed.
A further time is being sought on behalf of opposite party number 5.
And 1 and 2
also. 4.
And
I also for
opposite
open
party
up for
number 4 and opposite party number 5 to file their counter affidavits. So stop. List this matter on after vacation holidays. Set up within first 5 cases. Stop. In the meanwhile, if the counter affidavits are not filed, the court will impose cost. Stop. It is also expected that on the next date, opposite party number 1 shall make its stand clear. Stop. Next, since the petitioners are pursuing their BAMS course for last more than a year, and their admissions they have been cancelled. Admissions have been
No,
cancelled.
admission not yet cancelled.
Cancelled.
Not approved, my lord.
The
And
term is
their
cancelled.
admissions are not being approved now, under some direction of the National Council.
National Commission
for Indian System of Medicine.
National Commission
for Indian System
of Medicine.
Indian System of Medicine. First off, we direct that the which college?
Sri
College
College
shall
Research and
permit
Hospital.
the petitioners to attend the classes.
Practicals also, only classes.
Practical also.
Attend the theoretical and practical classes till further orders. So, list this matter on within first 5 cases.
And the second matter, opposite parties are the same.
Same.
5 and 6. The first matter, university is not a party. In the second matter, 5 and 6. First matter, it is opposite number 5.
Fresh submission item number 8.
Same order may be passed in second item. Sub-item.
Same one. Yes.
Item 8. Sir.
May I please? Yes. Input order is a case 14. That cost I have already deposited on 20th September.
About what? Cost.
I have already deposited in the account of the respondent, my lord. On 20th, I have also sent a copy.
Account of respondent or bar association?
Respondent.
Respondent.
Yes, ma'am. And the account of, I have also sent a copy to the.
Since it is deposited in her account, she has not given you instruction lest you ask for.
All right, let us see the order.
Yes, ma'am. Page 14, my lord.
My lord, I pray for adjournment.
Why, madam?
Mr. Samal will proceed with, sir. Any
No,
time.
this will have to be remanded, madam. There is nothing.
Why, merit also, she has no case. Only I will show 2 dates that my case stands. Lordship, paragraph.
If merit she has no case, then we have to adjourn for her senior to come.
I have no objection.
We are remanding it back.
Mr. Samal will address your lordship. Mr. Samal will address your lordship.
All right, tomorrow.
Next week, any date.
No, tomorrow. Ask him. Samal maintains a very good health and he is very regular. Tomorrow.
Okay.
I have requested on behalf of the respondent, list this matter.
Item 9.
Published.
Item 9. Adjournments have been given to OP number 5.6, that is the Tata Power, to file the counter affidavit. But they have not filed the counter affidavit and they are not appearing. And even if the state government is a party, OP number 1 is the state. State has also not filed a counter affidavit.
You can hear in the absence. They are not
So whether
interested.
in the writ petition, counter affidavit was filed. Is it writ appeal or?
This is writ appeal.
225, no? Why counter affidavit?
Writ appeal, counter affidavit is not required.
Counter affidavit is required, my lord.
Why?
I am submitting. My lord, in short, I am just making a short submission, my lord. The case of the appellants is that an advertisement was floated in the year 2011 inviting applications for recruitment of diploma engineers on contractual basis in SESU, Central Electricity Supply Utility of Odisha. In the year
Mr.
2011.
Counsel, please let us know why counter affidavit is required to be filed.
That I am telling. I am submitting with the lordship's permission. My lord, subsequently, after 1.5 years, the entire recruitment process was cancelled. Our grievance is that we were selected and by a cryptic 2 lines order, it has been cancelled. The only thing is that subsequently in the writ petition, they are taking the plea that there was power sector reforms for which the entire recruitment process was cancelled. During the process of, there was a board meeting in the 2010 and thereafter the recruitment was conducted. In this case, my lord, why the power sector reform is very important, my lord. Odisha is the first state in India to have a power sector reform in the.
Mr. Counsel, is this your reply to our query that in a writ appeal, why counter affidavit is required to be filed?
Counter affidavit is required, my lord. Entire impugned judgment is regarding the power sector reform. The power sector reform started in 1993, and OERC was Odisha Power.
So whether those aspects were the materials were there in the writ proceeding,
Miller,
whether those pleadings were there in the writ proceeding,
there in the
then why fresh affidavit?
Miller,
If those materials are already there on record, why is an affidavit required?
Miller, because we are not affected by the reform, Miller. That is the entire case. My entire case is that no service rule. That is the service rule guiding the field is that SESCO officer service regulation.
If they don't want to file a counter, why are you insisting? We can hear you and dispose of.
Miller, because we will be accommodated by the company. That's why whether they're in a position to accommodate us or not, and if not, why? That's why they should give the reply.
See, we are testing the judgment of learned single judge.
Miller.
That judgment is based on the pleadings which were there on record.
Yes.
All right.
Yes.
So we have to decide whether that judgment is correct.
Yes.
On the basis of the pleadings which they were there on record.
Miller.
You want that they should file a fresh counter affidavit.
Miller.
So will they bring on record certain new facts in the writ appeal?
Miller.
My lord.
The first ground is that.
Can they bring new facts on record at this juncture?
Yes, that is required because
at this juncture, because this is a order of this learned single judge is being challenged.
Miller.
So what is there
Mr.
is there
Counsel,
now?
we have not been able to convey to you, despite our best efforts, that we are deciding the correctness of the order based on the materials which were there on record before the learned single judge. So we cannot go beyond the materials which were there already on record before the learned single judge. The entire writ proceeding, copy of the writ petition is here. So what further affidavit is required to be filed? So you tell us that this order is incorrect despite the stand taken in the writ proceeding.
I am submitting. My first ground is that this is a service matter. The no service rule has been examined. That is, the service rule governing the field of appointment is SESCO Officer Service Regulation 2005.
What is SESCO?
SESCO Officer Service Regulation.
What is SESCO?
SESCO, yes, I am telling you. SESCO is a distribution license. SESCO is a distribution licensee.
SESCO is an English word.
Yes, Central Electricity Supply Company of Odisha.
Yes.
That is the.
So this is what we wanted to know.
Yes, that is SESCO is Central Electricity Supply Company of Odisha, and that was a private company, and it was a licensee for the distribution of electricity in the central zone of Odisha. Likewise, there are 4 companies: SESCO, WESCO, NESCO, and SOUTHCO, and we are concerned with SESCO, with the central zone. And my submission that, my lord, the law governing the recruitment in the field of electricity in SESCO is SESCO Officer Service Regulation. The impugned judgment is totally silent regarding the procedure to be adopted regarding appointment of the persons in SESCO, which was taken over by SESCO. I am clarifying, my lord. Insert the power sector reform started in Odisha in 1993. For that, the Odisha Electricity Reforms Act come into the picture in 1995. Milord, we are the selected candidates.
Selected candidates based on what?
Based on the selection.
Selection conducted by whom?
Selection conducted by the SESU.
By?
SESU.
SESU. When?
SESU in 2011.
2011. Thereafter, what happened?
Thereafter, Milord. Thereafter, the impugned order is saying that.
Forget impugned order.
Yes.
Thereafter, after
Lordship may come to the picture. Thereafter, Lordship may see the Annexure 1.
Well, after selection, you were appointed.
After selection, we are not appointed.
You are not appointed.
We are not appointed.
Just a minute. You were selected in?
Milord.
Issued letters, congratulation letters.
Selected in when?
We are selected in the
February 2012, Annex 3 series. The congratulations letters were issued to us through website.
You were selected.
We are selected
By?
in pursuance to page 86. Page 86 of the advertisement.
Selected by whom?
We are selected by the CESU, Central Electricity Supply Utility of Odisha.
Yes.
In 2012.
In 2012, advertisement was floated in 2011.
Thereafter, you were not appointed.
We are not appointed.
Then?
Thereafter, my lord, there was a, why you were not appointed, my lord? There was a one-line cryptic order at page 99. Page 99. That is the advertisement number 20125 dated 13 June 2011 and consequential selection for the contractual tenure post of diploma engineers, electrical and contract is hereby cancelled due to unavoidable reasons. No reason, nothing has been assigned.
There is nothing wrong. Though no service rule is applicable.
Minute.
You were not appointed.
Whereas, Lordship may turn to next page.
All right.
There is a similarly another advertisement for that is page number 100.
Yes.
Annex 5.
Yes.
Simultaneously, along with these candidates, another advertisement was published for recruitment of 1,000 persons of ITI training. That is junior attrition A. Just below this, the selection process continued, and these persons, 1,000 persons, were recruited. In our case, Miller also, there is a selective discrimination. The vacancy was advertised vacancy was 245. Thousands of persons applied, 647 persons were interviewed. And merit list of 203 persons published in which we were selected. But simultaneously, they didn't appoint us, whereas through backdoor entry, other 42 persons were appointed.
When?
In that, through that advertisement, Miller, since 2012, on the ground that previously they were working through agencies and they were till that they are continuing.
When were they appointed?
They were appointed, Miller. They were appointed in 2012, Miller, by session.
When was your selection list published?
2012, Miller.
So before they were appointed, before or after?
Miller, there is a simultaneously 245 posts. 203 posts were we are direct recruitees. They did not appoint us on the ground that there is some reform. Whereas other 42 persons who were working through contractors, they were engaged and observed.
Listen to the order. The present writ appeal has been filed selling where is the judgment? Selling
133, Annex 4.
Judgment dated 17/7/2003 passed in WPC number 2090 of 2024 and batch by a learned single judge of this court, whereby the learned single judge has dismissed the writ applications filed under Article 226 of the Constitution of India. Stop. Next. Learned counsel appearing on behalf of the petitioners, stating the impugned judgment has submitted that the petitioners had participated in a process of selection pursuant to an advertisement issued by CESU full form in the year 2012.
Their advertisement 2011.
2011. Stop. In the select list of 203 persons was published based on selection conducted pursuant to this said advertisement. The names of these petitioners figured in the list of successful candidates. Stop. He has submitted that after their selection, the after their selection, the SESU came out with a notice to the following effect, quote unquote, the advertisement number 20125 dated 13/6/2011 and consequential selection for contractual tenure post of diploma engineer - electrical bracketed contract on contract is hereby cancelled due to unavoidable reasons. So next, learned counsel appearing on behalf of the petitioners has submitted that appellants have submitted that the service condition of the employees of Cisco is governed by statutory rules which have not been taken note of by the learned single judge while dismissing the writ application. So he has argued that backdoor entries have been, the backdoor appointments have been met in the year 2012 to 12 against the vacancies which were advertised in 2011. Stop. Next. We do not find any merit in the present writ appeal for two reasons. Stop. An employer has a right to cancel a process of selection, and we do not find any illegality in the action of the CESU, total conduct, CESU in cancelling.
Millard, that is a Millard, I have judgments also.
Cancelling the in cancelling the advertisement. Stop. Secondly, merely because the petitioner's appellant's names figured in the select list based on an advertisement, they did not acquire any indefeasible right to be appointed against the posts advertised which had contractual tenure. Stop. We do not find any illegality in the impugned order requiring this court's interference. The writ appeal is accordingly dismissed.
Millard, may I am thoroughly prepared. Other thing is that I should be given a chance to make a submission. I have hundreds of judgments. This is a singular case. I say that, Millard. In all the impugned judgment,
Mr. Counsel, you have hundreds of judgments.
Millard.
We don't know those hundreds of judgments, but what we have understood, according to our experience, that we have written in our judgment, you can assail that.
Millard, one thing is that in the impugned judgment, the judgments have been cited.
The problem is that you cannot compel us to write a judgment in a particular way. So this is how we have written our judgment.
Millard, I should be heard and
you have been heard, and we have seen the.
May I request, with your lordship's permission, Millard? I may be given a chance. Since 13 years we have been waiting. 13 years we have been waiting. I should give I should give a chance to place my case properly, my lord. There should be court should patiently hear me, my lord. Because 13 years we are.
Counsel for the petitioner has insisted to hear him as he wants to press into service hundreds of Supreme Court's decision in case support of his case. Most of the said submission is hereby rejected.
Take instruction.
What is the order?
My lord, order, my lord. That is annexure
Yes,
one.
sir,
my-
not made.
Annexure one
Has
page.
come up without staff reporting. Right?
It is 23 years. Year of the 23, so.
List this matter on 1 week. So as to enable an AGA to seek instructions.
Because some matters are challenged before the Honorable Apex Court. File instruction on that whether this matter is also challenged or not.
1 week.
Yes, ma'am.
Item number 12.
Your lordships have heard this matter. This is regarding that height issue of 3 measurements and 3 your lordships were to pass the order only. Because your lordships had heard and we had filed the affidavit in pursuance to your
Must
lordship.
have heard long back.
We were apprehensive that in this time he may have acquired, become taller.
I'll see tomorrow will dictate this.
As your lordships.
Item 13.
13, my lords. This is regarding the mining lease so far as quartz and gemstone is concerned. So there was no reconnaissance, prospecting was required in this because it was an already reserved and identified area. So I'll just take your lordships to one document because the stand that has been taken for the rejection later on, because the earlier round of writ application, though they filed the counter, they never said that my application was rejected. So after this, Honorable Court directed me to make a representation to them to know what is the status. They have come up that it has been rejected since 2015. I'll just take your lordships to page 55.
Yes.
If your lordships would just last 4 lines of that, starts with these 3 numbers of ML applications. Your lordships got. Annexure 4, page 55.
Yes. Which part?
Lord, last 5 lines, these 3 numbers of ML applications are filed for mining lease, number so and so, of which 2 applications of Raghuvir Panigrahi, that is the petitioner, and so has already been recommended to Steel and Mines Department by this district office later, so and so. And in the next page, in view of the above situation, I request you to dispose of the same pending application for mining lease in village Badmal, facilitating to withdraw the deployed APR force as it is difficult to continue the deployment of 1 platoon of force for a long time, as there is need for force for ensuing Durga Puja and local festival because there was illegal minings were being carried out. And in the meantime, because what they have stated in their counter, that in view of the amendment in section 10(1), where it said that all the applications which are pending before 2015 will be deemed to have lapsed. I'll just take your lordships to section 10(1)(a) of the Act.
You are referring to which document?
My lord,
You're referring to which document where they say that because of section 10(1)?
yes, my lord, that is the impugned lord, later.
Annexure 1.
That is annexure 1. And if your lordship should see in 2024, they say that it has been rejected since 7/7/2015. But in
So
the
when you file the writ petition, this the earlier writ petition which was disposed of,
yes, they filed a counter. They never mentioned that it has been rejected.
oh, but whether after 2015 you were continuing with mining?
No, I'm not continuing. I cannot do it unless I have the license. There were illegal minings were going on. That is why the recommendation was made that these two applications may be taken into consideration. So, but after that, nothing was done by them. So I went on approaching them, and with all the documents and everything. In 2015, the amendment came. Thereafter, also they did not tell anything. When I filed the writ petition, they came back saying that we will take a decision, and on that basis, we withdrew the writ petition with the that will make a representation to them that they will consider.
No, but whether any counter affidavit was filed in that
Yes,
case?
my lord, in the earlier writ petition. If your lordships can call for also that record, I think that would clarify the issue. That other writ petition, my lord, number I'll just
20429.
20429 of 2015.
Well, let us see the provision in the meanwhile.
Yes.
Section 10.
10, my lord.
10A, capital.
10 capital, sorry, 10 capital A.
Capital A 1.
And I rely upon 10 capital A 2C to show the exception, my lords. May I place, my lords?
Yes.
All applications received prior to the date of commencement of the Mines and Minerals MMDR Amendment Act 2015 shall become ineligible. Then, my lord, the exceptions are given in 2. And I rely on 2C, if your lordship will see. Where the central government has communicated the previous approval
that
as
is 4C.
My lords?
2C.
2C.
2C, right.
Yes. As required under I'm sorry.
Yes, please.
Yeah, where the central government has communicated previous approval as required under subsection 1 of section for grant of mining lease, or if a letter of intent by whatever name called has been issued by the state government to grant mining lease before the commencement of the Mines Minerals Act 2015, the mining lease shall be granted subject to fulfillment of the conditions. So I say, my lord, that recommendation itself by the government to the, my lord, for the purpose. So that is my only case. Otherwise, my lord, I have zero case.
Recommendation or grant? It has to be grant.
My lord, that has to be granted by the government of India.
Only recommendation.
Recommendation. So that is my only case. That's why I said, my lord, I don't, I know I stand on a very weak footing.
That is why, since there was no grant, they have rejected those.
No, rejected this is since 2015.
Even if a lordship can see,
which was
D, my lord.
That amendment came.
No, in their rejection later, your lordships may see that annexure 1 at page 13.
There are only, C stipulates only 2 circumstances. 1, where the central government has communicated previous approval.
Previous, yes.
That is not there.
Not there.
And 2,
State
If a
government.
letter of intent has been issued.
State government,
So
by
neither
whatever
of the
name
two
it is called.
So only recommendation is not a letter of intent.
My lord, subject to that is my lord only, because there is otherwise nothing left in it.
Even my lord, in view of section 2D, my lordship can see. That has been inserted in the year 2000. That has been left. B and C both.
Yes.
And this is a case of
No, that
10A, not 10-2C.
No, because my first cause of action I filed in 19. That is how on the basis, because that 21 will not come into picture as on that date. I leave it to your lordship, sir.
Present writ application has been filed. Putting to challenge a communication dated 21/2024 issued by the Additional Secretary, Department of Steel and Mines, Government of Orissa, whereby the petitioner's representation dated 25/4/2023 for grant of mining lease. Mining lease has been rejected. So the petitioner's application for grant of mining lease was admittedly filed on 18/6/2005. It is the case of the petitioner that who had recommended
Collector.
that the collector had recommended for grant of mining lease, which remained pending. Stop. The body of the impugned communication reads thus. Stop. Next. When senior counsel appearing on behalf of the petitioner has submitted that the provision under section 10, capital A, bracketed 1,
2C.
section
1 is the lapsing. 2C is retaining the rights, exceptions.
Therefore, just see the sentence. Section 10, capital A, bracketed 1 of the Mines and Mineral bracketed Development and Regulation Act 1957 is subject to the exception under section 10 bracketed 2 bracketed C of the said act. So stop. He submits that as the petitioner's application for grant of mining lease in 2015 was considered and it was recommended by the collector, comma, his case is covered by section 10 capital A bracketed 2 bracketed C of the Act. So stop. Section next. GA representing the state of Odisha has submitted that the petitioner's case does not fall in the exceptions under subsection 2 for the reason that no letter of intent to grant a mining lease was issued before coming into force of the Mines and Minerals Bracketed Development and Regulation Amendment Act 2015. Full stop. 2015. Next. So as to address rival submissions advanced on behalf of the parties as noted above, we need to reproduce the provision under section capital A of the Act, which reads as under. So stop. In no uncertain terms, subsection 1 of section 10A capital A provides that all applications received prior to the date of commencement of the Mines and Minerals Bracketed Development of Regulation Amendment Act 2015 shall become ineligible. Stop. The said Amendment Act, Amendment Act 2015, bracketed Act 10 of 2015. Stop. Act 10 of 2015 came into force with effect from 12/1/2015. Stop. C. Bold color.
The ordinance and then thereafter, right?
Milo?
There was the ordinance. Thereafter, this section came.
Milo.
It is we do not find any ambiguity in subsection C, in clause C of subsection 2 of section 10 capital A of the Act, which provides that which stipulates two circumstances for application of the exception clause under subsection 2. Full stop. They are: one, where the central government has communicated previous approval as required under subsection 1 of section 5 for grant of mining lease. 2, if a letter of intent, comma, by whatever name called, comma, has been issued by the state government to grant mining lease before commencement of Act 10 of 2015. Stop. In the mere recommendation by the collector in favor of the petitioner, comma, in the court opinion does not amount to issuance of a letter to grant a mining lease. So stop. Since none of the circumstances stipulated under clause C of subsection 2 of section 10A exists, comma, we do not find any legal infirmity in the impugn communication dated 20/21/2024. We do not find any merit in this application, which is accordingly dismissed.
Okay. Item 14. My lord, is similar to item 49 of today's list, which is fixed at 2 p.m. It may come along with 49, my lord, I pray.
Yes. What is that?
168
capital A of the CGST Act, my lord, the notifications that the authorities issued
Those
and
matters will be heard today.
yes, my lord, I fixed at 2 p.m.
Similar lordship passed earlier.
All right, we will take up although today we are heavily
At 2 p.m. it was
2 p.m. it has been.
2 p.m. we have to dictate a judgment. We will try. We'll take.
Item 15.
This writ application, my lord, the petitioners have challenged the establishment of ethanol plant in village Deoga, Kambalpur. Have challenged it on several grounds. First of all, them is, my lord, before such
15.
establishment. Your lordship,
I have appeared for opposite fund number 4 pollution control board yesterday. I'll file a counter. The main allegation is the consent granted for establishment of the unit by the pollution control board. I will file a counter explaining my stance.
I am appearing for the opposite part number 1. Ministry, Union of India.
I think 1 week time I will.
when notice has to go, my lord, the company has not been issued notice. Opposite
Company we will not issue notice, let them file their affidavits.
party.
For the present, we are not inclined to issue notice to the opposite party number.
7.
Is the company.
6 is the sarpanch of the Gram Panchayat. 6
No,
also.
7. 7. We will consider this of notice after having seen the stand which may be taken on behalf of opposite party number 1 and 4. Stop. This opposite party number 4. Opposite party number. Mr. So-and-so accepts notice on behalf of opposite party number 1 and 4. You or for party number 4?
I'm for 2, 3, and 5, your lordship.
3 and 5. So 4 weeks.
Pollution control board.
4 weeks. 4 weeks.
Time is out for
Yes, time.
pollution control board to file an affidavit. Counter.
A counter of the sarpanch is also required because they have given consent without following the procedure prescribed under law. Opposite partner 6. So lordship direct notice against opposite partner 6.
Let him file affidavit.
These minutes. Plus the petitioner was the successful bidder of a sand bed quarry. Plus the agreement minutes is at page 13 minutes.
Page
13 minutes.
No, just one.
Balance. That's on the earlier occasion, your lordships directed me, the annexure 2 was incomplete. So your lordships directed me to file an additional affidavit. I filed that. I have annexed it again. Like 10 because plus 2 is incomplete. So I annexed it again. So let's that I have filed. First one to lordship's last order. Now let's, if at page 13 is the quarry lease which was executed, the location your lordship will find at page 19.
Yes.
It says village Lungei, Tahsil Lathikata, district Sundargarh. Now, before there could be commencement, we were hit by COVID. Then, if your lordship will kindly see page 34. This is the letter from State Environment Impact Assessment Authority for the transfer of the environment clearance, which was there in the name of Tehsildar to my name. the quarry name, the lessee's name. So this is that order whereby the transfer was made on 28th April 2023. Plus this letter is incomplete, so I beg your lordships to refer to the additional affidavit. Now thereafter, there was a consent to establish also, which your lordship will find at page 37. There was a consent to establish from the State Pollution Control Board. That was there on 3rd May 2023. The consent to operate is also there, which your lordship will find at page 40. Now, while all these things are there, in the meanwhile, there was a litigation before your lordships, before this honorable court, where certain directions were made insofar as the transportation of the sand during particular hours of the day. So there, my lords, if your lordship will kindly see page 48, my lords.
Yes.
My lords, this is by the mining officer, come competent authority, Rourkela, which is addressed to all the sand beds, my lords. It says there's a reference to writ petition number 6375 of 2023, my lords. It says, in inviting a reference to the subject cited above, I am to request you to please go through the enclosed sheet, date of hearing and judgment on dated such and such of the Honorable Acting Chief Justice and Honorable Mr. Justice Murari Sri of Orissa High Court, dated such and such, wherein page 22, in para 20, it is mentioned that now, coming to the question of protection of environment and checking of the movement of vehicles during the daytime, Mr. Parija, Learned Advocate General, very fairly stated that there should be restriction of movement of vehicles carrying sands from 7 a.m. in the morning till 9 p.m. in the night. Page 23, para 22, state giving priority to the sand mining by manually, and as per your approved EC, you can manually continue sand mining. Well, that's the only thing I restrict my submission is, with respect to that timing, from 7 a.m. to 9 p.m., there shall not be any transport. Because that judgment also, if your lordship will permit, I'll just give your lordship that judgment which was passed. My learned senior sitting next to me was there in that matter.
Yeah.
Well, we'll see para 20 of that judgment. This para 20 is what is referred to in that communication under annexure 5. Now coming to the question, Malats. Malats finds para 20.
What is this letter? I can't understand. 49.
49 minutes is that letter where it is communicated with regard to the timing of the transport, 7 a.m. to 9 p.m. But Millet's your lordship will kindly.
Daytime they are not allowed to leave.
At the
night time they are allowed to leave.
Yes, but Millet's, my difficulty is now the Gram Panchayat. This is why I am before your lordships. Now the Gram Panchayat of that village, they have passed a circular. They are in protest. They have passed a circular saying that you will not be permitted to transport during the night time. It causes noise pollution and all those things. So you will not be permitted to transport during the night time. You can do it during the daytime. Nonetheless, that is the difficulty for which I have made representations to the authorities, Millets, and those representations are not being considered. And here, Millets, my lease period would be expiring. I was the successful bidder. I came in as a bidder. Now today I am stuck between the two situations. Because
Mr. Dalai will have to be implicated as a party in the presentation.
He is there to assist.
No, he's a party.
Always there.
He has filed that PIL.
Therefore,
and Malaj will see the Gram Panchayat's decision at page 50. It says you transport during the day, don't transport during the night. Now, and they are protesting. So I am now stuck. So that is my situation for which I have approached the authorities. The authorities are not taking any steps. Therefore,
no, they've granted you time from 4 a.m. to 4 p.m.
Plus, it is
3 hours. So you have 3 hours.
Only. was the sand, this. And this has been duly communicated by the competitor.
My lord, notice to go to the Gram Panchayat, my lord. Gram Panchayat is a party, my lord. Opposite party 3, my lord.
What is it?
No, I understand, my lord. In fact, my lord, the Gram Panchayat, the Sarpanch is creating, they are creating all the, because they have written a letter.
No, they are also, their stand is also very reasonable. Because in the night,
My lord.
they sleep. The old people, ailing people suffering from ailment, they also have problems.
My lord.
So they are also justified in their decision. Students study.
In fact, sometimes when you make construction on the road, has to be granted, otherwise they can't operate.
There are two aspects. One, traffic because of the heavy vehicles, and two, environment issues because of the nature of this thing.
Machinery use.
Sand. No, sand. Oh, if that is properly covered,
Well,
if it is properly covered, I don't.
In fact, my lord, there are directions, my lord, to cover the truck, my lord,
Yes,
while
that
moment.
is covered. In fact,
that they're doing.
Water is also added so that it doesn't fly.
Flying,
they're
so
doing.
sometimes hits the windshield and cracks it.
Yes, sprinkle it is difficult.
What?
In village road, you have to.
Not the road. The sand itself,
Sand
it is
itself
sprinkled
also
with water so that it doesn't fly as a
Fly.
dust.
Then that should be covered also.
And then that is covered.
That is covered, my lord.
That is standard.
On each truck, my lord, that is covered onto the. By the.
File your affidavit,
My
we'll
lord.
see. We'll-
But is this being followed of that Gram Panchayat serial number 4?
My lord.
How are you checking?
Drunken driving inside.
How are
my
you
lord.
checking that? That is very essential.
My lord.
But whether you can check.
I have one also alternate submission. Your lordships, that judgment. What has been done is in that communication by the mining officer, para 20 has been referred. But if your lordship will kindly have a look at that judgment, the honorable court's decision is in para 22. Para 20 is only a submission of the learned advocate general. Para 22, rather, Millards is the direction. And in that direction, if your lordship will see, para 22, in view of such position, this court disposes of the writ petition directing the state government to scrupulously follow the guidelines framed by them on 21st December and also adhere to the conditions stipulated in the lease deed executed between the lessee and the state, giving priority to the sand mining by manually. Further, the state authority should take necessary steps with regard to vehicular movements from 7 a.m. till 9 p.m. and also protect the environment to provide a quality life to the public at large.
What is that necessary steps?
Yes, because that is something, therefore, what my humble submission is, that there is adequate leverage given to the state also to take necessary steps to face situation like this that we are today, in order to strike a balance. So, only thing, if I may request, if your lordship will put it on a short date, considering the...
While you see, there is no direction that there should not be any movement from 7 a.m. till 9 p.m.
Well,
there is no such direction. Please read paragraph 22.
Well,
to take necessary steps with regard to vehicular movements. So what steps have you taken?
Well,
whether steps have been taken?
Well,
whether anything has been done?
No steps have been.
Then who is stopping you?
That communication, annexure 5. That is the difficulty.
But from 4 a.m. to 7 a.m.
3 hours. These are, and it has to pass through a village. We can't also and they can't also drive fast to cover more. That is also impossible.
See, there is nothing in this order. This order does not stop you. This order simply directs the state government to take appropriate decisions.
I'm so great.
Whether they have taken appropriate decision, we don't know. But the panchayats, they have taken a very valid decision.
Plus, both they're right in there.
What was the order here?
No, state government has taken decision, but as per the rules 4.6, lordship, rule 4.6, Panchayat has absolute power, lordship. Under rule 4.6.
I know you are the champion of this.
No.
Panchayats.
No, not only that, the decision of the panchayat appears to be
Reasonable.
very reasonable.
They have vested the power also, lordship, under the rules.
For
They
the
have that
convenience
power.
of the people also they
Lordship.
have considered.
They can take a decision because they are the person to give.
If all the they have to.
Both have to coexist. You have allowed them
My
to
lord.
take side. What
My
time is so that they
So
have.
whether Raj department is a party.
Panchayat Raj Department. No, let's.
Gram Panchayat is a
Gram
party.
Panchayat is the party.
Gram Panchayat is a party,
My
whether the department is party or not.
No, let's.
Complete party.
Even if the state is not a party.
It is a schedule area. To Sundargarh,
State
it
is not a
more
party.
State is not a party.
The Tahsildar, the mining
not the
officer.
State complete state. It's a policy matter.
Very well. I'll take steps in the
Amend
meantime.
the cause title and then.
Months.
I requested on behalf of the matter on 1 week, so as to enable him to take steps for amendment in the presented application. To make it more comprehensive.
Plus the cost title only, I'll amend minutes.
Just think of. We request Mr. Dalai Land Council to assess this court as an
Lordship.
So this is balancing.
Yes, please. Well, as I am stuck at the center of the balance, Phillips. I can't go either ways, Phillips.
Yes.
I'm so grateful.
Item 17.
In fact, item 17 tested this matter, lordship.
I thought you are sitting here in that matter,
No, no.
watching. All right. Yes.
Lordship, yesterday this matter was on board, lordship, and a lordship passed order to leave this matter on 30th, lordship. Why it has come once again, lordship?
This was adjourned to 30th.
30th, lordship.
Wrongly listed.
Yesterday it was.
Yeah. This matter on 30th. Yes.
Item number 19.
See, public interest litigation. My lord, the grievance of the petitioner, sir, though the state government has issued a notification under Annex 1 way back in 1st of June 2015 to provide, I'm placing page 17, in suppression of all earlier orders on circular issued by the Higher Education Department concerning the reservation of seats for admission of scheduled caste, scheduled tribe students, the government have been pleased to order for enhancement of
So
reservation.
this is PIL.
PIL.
Have you followed the rules?
Yes, my lord, I follow.
Have you mentioned that you don't have any personal interest?
Yes, I have mentioned in paragraph 1 that the present writ petition being filed also by your public interest litigation and the petition have no personal interest.
Which, see, it seems WPC 21890.
Sorry. Double two.
Next
no,
item. Just
Next.
22251.
18, 19.
No, 19. 18 adjourned.
Shiva, Monday. Oh, this Amira. Okay.
Yes, this is different.
22251.
Yes, what is your cause?
Your Lordship, the reservation, Your Lordship, Annexure 1 at page 17.
Yes.
In supersession of all earlier order circular issued by the Higher Education Department concerning the reservation of seats for admission of scheduled caste, scheduled tribe students, the government have been pleased to order for enhancement of seats for admission of all the scheduled caste and scheduled tribe students in all the government aided institutions and under the control and jurisdiction of the Higher Education Department of the state, including the university as follows. 22.5% seats shall be reserved for scheduled tribe students. 16.25% seats shall be reserved for the scheduled caste students. But this has not been followed in higher education, that is engineering and medical. That part, no reservation is provided for OBC students. That is the main crux of the matter.
So is there any mandate?
My lord, after Article 15.5 came into, and there is
read Article 15.5.
Well, nothing in this article or in subclause G of clause 1 of Article 19 shall prevent the state
So
from
this is the difference. Nothing in so and so shall prevent.
Yes.
All right. So it does not mean that it commands.
Right.
It's a enabling provision.
Enabling provision, right. Well, accordingly, the central government brought the Central Educational Institution Reservation and Admission Act 2006. Central Educational Institution Reservation.
Therefore, invoking that permission under 15.5, this decision has been taken by the central government.
By the central government.
Central government decision is not binding on state government.
No. I am bringing you, Your Lordship. Paragraph section 3 provides out of so and so, out of the annual permitted strength of the bench so and so, 27% of the states shall be reserved for the seats shall be reserved for the OBC classes, other backward classes. And the state government in 2008 has brought an act, the Odisha Reservation of Post and Service for Socially and Educationally Backward Classes Act 2008. Lordship, this is the act. Lordship,
that is different. Whether that will apply for admission?
No, that is for the employment.
So it is them to decide.
Yes,
we will not decide.
They will decide, and accordingly, this Annexure 1 they have decided. Lordship, I kindly have a glance to Annexure 1.
Annexure 1? Yes.
So the writ petition at page 70.
Yes.
They have decided this, but they are following.
They are not following.
They are not following
This notification.
this notification.
Yes, is that so? Finally, reference for which time is allowed. It is precisely the petitioner's case that the state government functionaries are not abiding by the notification dated 1/6/2015 prescribing reservation for scheduled caste, scheduled tribe and scheduled caste students for admission in government and aided educational institutions under the control and jurisdiction of higher education department of the state, including the universities. Stop. let a counter affidavit be filed on behalf of the opposite parties by 4 weeks. Rest this matter on 6 weeks.
Item number 20.
May I please your lordship? This is a matter, my lord, where the petitioners belong to AC community applied for tender, my lord. And I have filed application for relaxation on the security deposit, my lord. On the last occasion, your lordship want to see the brochures. At paragraph 3.0 at
Yes.
page. At
You hold
page,
power in this case.
yes,
Item 20.
my name is wrongly reflected as Jena. SK Jetty.
Jena is so?
Jetty, my lord. My name
You are
is
GT, not Jena.
wrongly it has.
20.
Yes, what is your grievance?
I have given the brochures on the last occasion. Your lordship wanted to see the brochures of the tender, my lord. At if your lordship.
Oh, yes, that matter.
Yes, ma'am. If your lordship turn to page 49, at the bottom the page number is there, my lord. Page 49.
Someone is appearing for the other side.
I have given copy to the Union of India and
No, Union of India is not.
For Indian Oil Corporation and IOCL, I don't have found any lawyer, my lord.
You should notice. Yes.
21.
1 week, 6 weeks. Yes.
Well, I am appearing for the Union of India.
All right. So notice.
21.
Ultimately, matter was listed, my lord. As per your last query, the order of the collector on 19/7/2020, and I filing this with an affidavit. That the
File in the registry, not here.
the matter, since the matter has been listed, appeared today and for that. 19/7 order, which was the of the collector Kandhamar, the blacklist was lifted. You run up to page 6 of this, the last page of the order. And taking into consideration that aspects, your lordship has passed the order on 24/7/2024. At the last part of the order, however, considering the representation of the agency, the word of blacklisted is hereby. The said agency shall not participate for providing different categories of manpower on outsourcing basis on coming next 3 years in Kandhamal district. That was the order. And with that, taking into consideration that order, your lordship has withdrawn that stigma by order dated 24/7/2024 in WPC number 40185 of 2021.
That it seems submitted by us.
And my tender has been rejected only on the ground that I have been blacklisted.
You have been blacklisted, in fact.
My lord?
You have been blacklisted in Kandhamal.
Yes, my lord.
Yes.
But decision in Nuapada that has been on your page, your
Whatever.
lordship shall do to page
You have
20.
been blacklisted. Why did he withdraw the word blacklist, or because the procedure has not been very interesting? What is this order?
The lordship shall look to page 6. My technical being rejected on the ground that I have been blacklisted. Since the blacklist has been withdrawn and the stigma which was imposed that was lifted by.
But what is the meaning of you will not participate in?
Kandhamal?
Yes.
Yes, madam. But it is a Nuapada, madam.
No, maybe Nuapada, but what is the meaning? Why have they asked you not to participate for 3 years?
That is the order for which that order I have challenged before the lordship. And that was taken into consideration and passed the order. 2021 and taking into consideration the lordship past order, that is in page 28. Page 28 for this.
So where is our order?
Is page 28. Page 28.
Page 28.
Yes, ma'am.
How could you get that order from us?
Showed another order.
So therefore,
the observation of this court is in page 29. Considering the facts and circumstances and the nature of impugned order which has been passed, we dispose the present writ application with an observation that no observation made in the impugned order dated 19/7/2021 shall be treated to be a stigma against the petitioner for any tender in which he may participate after 19/7/2021.
there is a typographical error. It should have been 19/7/2024. There is typographical error in the.
Because the order was passed in 2021, so it has become ineffective on in. That's all right.
So there appears to be a typographical error.
Yes, Your Lordship. Because the date of proposal for submission was
All right, we will modify that
29/1/24.
order. After 19/7/2024, you can participate, but not before that.
His case is that he had been applicable only to asked not to participate only in Contempt.
That is material.
That is different.
My respectful submission, taking into the technical bid was opened on 30/7/2024. And on that date, he was rejected my bid.
Because
And
when you
accordingly,
applied, it was there. When you applied, that 19/7/2024 date had not yet come.
At the time of application, that was not come.
First of all,
But
let
at
us
the
correct our
at
order.
the time of consideration of technical bid, that was admitted.
Upon perusal of the order dated 24/7/2024, passed in WPC number 40185 of 2021, which has been brought on record by way of Annexure 4 to the present writ application. It appears to us that there is a manifest typographical error in the said order, as much as in the last sentence 19/7/2021 has been typed in place of 19/7/2024. Top list WPC number so and so along with the present matter tomorrow for correction in this said order.
My respectful submission, my lord.
We will consider your.
Yes, my lord. Yeah,
First of all,
Tomorrow we will
yes,
consider.
change it and then we
No,
will
no, my
consider.
respectful submission, but the blacklist are lifted. It is only for the Kandhamal district. So that is not applicable. The blacklist is not applicable in view of the order passed by the collector to other districts. But it is a Nuapada district. I am applying for Nuapada district.
That is one thing,
So,
but collector can also
Nuapada-
consider.
See, Nuapada or some district in West Bengal, they may also consider that you were blacklisted at some point of time for a particular
Yes, my
period.
lord. Your lordship.
So
But
they are evaluating your performance, past performance for the purpose of grant of a contract.
But my
Had that line not been there, who is not allowed to participate, would have been different. Because of that line, we are
no,
reconsidering.
that line is there. The blacklist
Yes,
is
for-
lifted, and he can participate for 3 years in the Kandhamal district. That is the line.
Cannot.
Cannot. He cannot participate in Kandhamal district for 3 years,
Yes.
but not for other districts.
That will consider.
That's not for other districts. madam.
Item 22. 22.
ଆସିବନି ପୁଣି 3 ଦିନ ଲାଗିବ।
Lord, in this matter, Annexure 1 and Annexure 2 are under challenge. Annexure 1 is an order of cancellation of a quarry lease. Annexure 2 is the demand letter. Lord, we'll find the cancellation order, page 22. The ground of...
So do you have any alternative remedy?
Yes, my lord. There is an alternative remedy in form of Rule 46 of the rules. But, my lord, I have taken specific plea why the alternative remedy may not be applicable and may not be efficacious in the facts of this case. My lord, the averments, my lords, will find at paragraph 30.
Applicable, if not applicable, it's all right, but not efficacious.
Not applicable per se, that would be my first submission. Lord will see that this order is passed by the sub-collector, Khurda cum competent authority.
Yes.
But this is competent authority under the Jagannath Temple Act, Puri. Secondly, my lord, this order is based on an
Jagannath Temple Act?
Puri, Sri Jagannath Temple Act 1955. And an anomaly happens because, my lord, shows notice.
No, please come again.
Yes,
the submission which you made.
Yes, my lord. Lord, this order is passed by the sub-collector, Khurda cum competent authority, acting on behalf of the Sri Jagannath Temple Office. The show cause notice was issued by the chief administrator. And the demand notice is issued by the OSD, Officer on Special Duty Development. And the inquiry based on which this cancellation has been made was conducted by so-called mining consultant. Well, my submission is threefold as far as the alternate remedy is concerned. Lord, the officer who has purportedly passed this cancellation order is not a competent authority under Schedule 4, Column 4 of the OMMC rules. Secondly, my lords, the scheme of the Rule 46, which provides the authority from whom an appeal would lie. My lord, may please have a look at that Rule 46. This is the first difficulty here, my lord, apart from violation of natural justice and without jurisdiction contentions. Lord,
yes.
I have sub-rule 1, may I please place it? Any person aggrieved by an order of the competent authority. Here I stop, my lord, and will take my lords to Rule 2F, where authority is defined. That would be at page 13, I believe, of that book.
Yes.
Page 13, competent authority means officer mentioned in column 4 of Schedule 4.
Yes.
Now, my lords, may come to page 116. 116 would be Schedule 4. Serial number 2. Minor minerals other than specified minor minerals. Here, my lord, the query lease is in respect of building stone. My lord, has page 116.
Yes.
Lord, we'll see serial number 2. This is the category of minerals, minor minerals other than specified minor mineral, which is applicable. Here, this is building stone. So this is other than specified minor mineral. Column 2 says type of lease. query lease and query permit, A, when occurring within village boundaries, B, when occurring within forest areas. So here it is a lease occurring within village boundaries. So therefore the competent authority, my lord, is under column 3, the Tehsildar, and then column 4, Revenue and Disaster Management Department. This is the first point, my lord. Then coming back to Rule 46.
Columns are different.
It appears that there is an error because that is the appellate authority.
Serial number 1, they have given 1. So this competent authority under column 4.
No. See, that column 4 is simply department, not the appellate authority.
Yes, my lord.
It is just name of the
That
department.
is the reference was only as far as competent authority referred in Rule 46.
Yes.
Here it is Tehsildar.
Lord, will go back to Rule 46. Now, any person, Lord Sir,
Yes.
any person aggrieved with the order of the competent authority may, within 1 month from the date of communication of the order, prefer in an appeal in Form X against such order to the sub-collector if the order is passed by the Tehsildar.
See, but one link is missing.
Yes, ma'am. Grateful.
You have referred to 46.
Yes, ma'am.
You have referred to competent authority.
Yes, ma'am.
Then you have taken us to 2F,
2G,
the definition of competent authority. And from 2F to this schedule 4.
2G to
Competent authority to do what?
when under to pass an order. Now that order, my lord, will see that provision is under 3319. 3319. Rule 3319 at page 55.
Yes.
If any government dues payable under the lease deed remain unpaid for 1 month beyond the date fixed in the lease deed, for such payment, the competent authority or any officer authorized by him may enter into the leased area and seize all or any of the minor minerals or other movable properties and may dispose of such seized minerals or properties towards sufficient satisfaction of the government dues and all costs and expenses.
So your submission is that he was not competent to pass this order.
That is one submission, not competent to pass the order. Secondly, my lord, this order is based on a report, inquiry report of the mining consultant, which my lord would find.
No, you are coming, now you are addressing on the illegality of the order.
Jurisdiction.
That jurisdiction is one part.
Illegality because of illegal. Yes.
And illegality because non-compliance of the principles of natural justice, some inquiry report prepared behind your back, therefore.
Not furnished to me, not supplied to me.
So those aspects, points can be taken by you before the appellate authority.
Millets.
All right. So far as the competence is concerned, yes, we will see who is appearing for the other side.
Jagannath Temple. Jagannath Temple.
Mr. Satpathy,
My lord.
serve a copy.
Serve a copy, we will take up tomorrow.
Mr. Subrat Satpathy.
Why didn't you serve? Let a copy of the requisite number of copies of the writ application be served upon and counsel represents opposite party number
3 2 3 4.
This matter 1B
2 3 4 5.
2 3 4 5.
Yes.
Item 23.
Obliged.
23, my lords, I'm for the appellant. My lords, on the last date, this is a contempt appeal. Yes, your lordship had raised a question on maintainability. I have done some research. Your lordship may just permit me just one. There is a Supreme Court judgment which says this is in 6 Supreme Court. Your lordship may just. The Honorable Apex Court has laid down certain guidelines regarding contempt jurisdiction. Your lordship may only take page 9 of that judgment, page 9, subpara 5, Roman 5. I've marked it also.
Therefore, you are right.
Yes, so my lords, intra-court appeal will lie.
Intra-court appeal, not the contempt appeal.
Not contempt. So my lords, I'm praying that I'll file an IA2 for conversion of this.
No.
My lords, may grant me liberty in that case to file appropriate appeal.
Petitioner after some appellant after some argument seeks permission to withdraw this appeal. The top London Council has relied on a Supreme Court's decision in case of Midnapur so and so reported in 2006 volume 5 SC 99. Paragraph.
My lords, paragraph.
Just now
This is
you-
paragraph 11, subclause 5.
Subclause. So, with particular reference to subparagraph Roman 5 of 11 thereof, which reads as under. So, she submits that she may be granted liberty to question the correctness of the impugned order by filing an intra-court appeal. Stop. No such liberty is required to be granted. So, if according to the petitioner, appellant, the case is made out, there is no restriction for the appellant to file an intra-court appeal if so advised.
Well, you are rightly saying paragraph 11, I'm assisting because I was lawyer for the running honorable court. Your Lordship, 2006 paragraph 11 is saying that if any punishment or anything, then can.
No. If there is any question on issue, my lords, if any issue has been decided.
Law is very simple. Law is that if in a contempt proceeding, the contempt is dropped, then appeal under the contempt of court shall not lie. But if while passing an order in exercising contempt jurisdiction, the learned court issues certain direction,
Yes, ma'am.
then that part can be treated to be an order passed in exercise of power under Article 226.
Grateful, ma'am.
Therefore, writ appeal.
Yes.
Yes, ma'am.
In 1988 Supreme Court also, my lord's view is expressed Supreme Court has said.
My lord's view is based on those decisions.
Yes, 1988 also.
So you're supporting her submission?
No. I am opposing, my lord.
You are saying that even intra-court appeal will not lie to of the nature of order passed. No.
That is satisfied.
All right, we will see. If she wants, she can do. See, anyone has liberty to file.
Yes.
any
Liberty.
application.
Yes.
Your Lordship may permit. Mr. Senior Advocate, Mr. SP Misra.
Very difficult.
There.
Yes.
Grateful, my
Happiness,
lords.
ma'am. Obliged.
For orders item number 30.
No. Judgment का 30 है. the petitioner is a company incorporated under the Companies Act, having its registered office at Mumbai. The present writ application has been filed for declaring opposite party number 3 as ineligible for request for proposal bracketed RFP inviting tenders for operation and management of integrated patient transport and helpline service bracketed phase 2 in Odisha, bearing RFP number OSH and FWS /01/2024 /IPD THHS Roman 2. Oh, stop. The opposite party number 3 has been declared L1 in the tender process. Tender process. So stop. It is the case of the petitioner that the petitioner suffers disqualification stipulated under clause 1.2.5 comma 1.2.7 and 3.3.2 of the RFP document. Stop.
OP number 3.
Petition.
Number 3 suffers
Oh, sorry.
Said petition.
Sorry. OP number 3. So, considering the challenge, nature of challenge, which has been met by the petitioner in the present writ application, based on the averments met in the writ application, it would be apt to reproduce here and below the aforesaid clauses 1.2.5, 1.2.7, 606. it is the petitioner's case that opposite party number 3 was blacklisted by, where is the order of blacklisting? Blacklisted also. Where is the blacklisted? 538, 539. Sorry. Oh, blacklisted 530. By the Commissioner of Health and Family Welfare Department, Government of Karnataka on 2011-2023. Stop. Further, the National High Health Mission bracketed OP number 3. Further, National Health Mission bracketed NHM Government of Meghalaya had suspended the contract of opposite party number 3 with NHM by way of a closer notice dated 8/8/2023. Stop. It is accordingly the petitioner's case that since opposite party number 3 was blacklisted and suffered the order of suspension passed by NHM Government of Meghalaya, the technical bid so submitted by opposite party number 3 ought to have been rejected. Stop. Petitioner was found L2 in the bidding process, and it is accordingly the petitioner's case that the work ought to have been awarded to him. Stop. Next, Mr. Mohanty. Next, it is the case. A counter affidavit has been filed on behalf of opposite party number 3, stating therein that the order of blacklisting dated 27/11/2023 issued by the Commissioner of Health and Family Welfare Department has been stayed by the High Court of Karnataka in WPC number 27840 of 2023. The order of stay is still operating. So stop. As regards the suspension of the work ordered by NHM, Government of Meghalaya, it is the case of opposite party number 3 that there was such order of suspension was passed during the subsistence of the period of contract between the opposite party number 3 and Meghalaya government. Stop. It is a Meghalaya government after expiry of the term of contract. The term was extended for certain period, and because of inevitable circumstances, the Meghalaya government had decided to suspend the project, which has no adverse suspended the project, which does not amount to suspension, so as to attract clause 1.2.7. Suspension is 1.2.5 of the RFP. Next, Mr. Mohanty, learned senior counsel appearing on behalf of the petitioner, has argued that the fact that opposite party number 3 has been blacklisted is not in dispute.
Yes.
Is not in dispute. So stop. Though merely on the ground, on the basis that an interim order of stay is operating passed by the High Court of Karnataka, the opposite party number 3 cannot claim that there is no blacklisting order against him, against it. So stop. He has further argued, with reference to the documents which have been brought on record, that the project which the petitioner, the project in Meghalaya undertaken by opposite party number 2 had to be suspended because the opposite number 3 had to be suspended because opposite party number 3 was not able to carry out the work. In such circumstance, it was obligatory on the part of opposite party number 3 to have disclosed this fact at the time of submission of its bids, its bid. Full stop. He has submitted that had this fact been disclosed and the matter been disclosed, the technical evaluation committee would have the opportunity to duly assess the eligibility of opposite party number 3. First off, non-disclosure of this crucial fact amounts to suppression, and on this ground also the technical bid ground also the opposite party number 3 should be declared disqualified for participation in the financial bid. So stop. Next, Mr. Mishra and senior counsel appearing on behalf of the opposite party number 3 has submitted that the order of blacklisting dated 27/11/2023 issued by Commissioner of Health is ineffective and was ineffective as on the date of submission of bids by opposite party number 3 by operation of the order of stay passed by Karnataka High Court in WPC number 27840 of 2023. Stop. The order of blacklisting, such order of blacklisting could not have been considered against the petition, as that would have amounted to ignoring the order of stay passed by the Karnataka High Court. Stop. He has further submitted that opposite party number 3 was not required to disclose any fact, that there is no suppression of any material fact as regards the suspension of work ordered by suspension of the project ordered by the NHM, government of Meghalaya. He has relied on a communication made by the Meghalaya government, which government to contain that there was no order of suspension during the currency of the contract, agreement of contract between opposite party number 3 and NHM Meghalaya. This is all, Mr. These are the submissions.
Milord, the only thing, Milord, that the Karnataka issue we declared, that was part of my declaration.
No, that is not. That is. He is not submitting that. You did not declare. Regarding suspension only, is this fact ought to have been.
In the petition, in fact, they say that we did not declare that also, but that is but that doesn't matter, Milord. It makes no difference. Your Lordship has got the gist absolutely. I'm grateful, Milord.
Mr. Tripathi, you have appeared for whom?
I'm appearing for the opposite part for 2, my lord, National Health Mission, which was quoted the tender.
Mr. Tripathi and counsel has appeared on behalf of opposite party number 2. Who is opposite party?
National Health Mission.
National Health Mission, Odisha.
Odisha.
Stop. While supporting the, while opposing the prayer made in the writ application, he has adopted the submissions advanced on behalf of opposite party number, submissions made by Mr. Mishal and senior counsel. Stop. We have carefully examined the pleadings and other materials which are on record and given our thoughtful consideration to the arrival submissions made on behalf of the parties. Stop. We do not find any force in the submission made on Mohanty that the order of blacklisting passed by Commissioner of Health, blacklisting issued by Commissioner of Health and Family Welfare Department, Government of Karnataka, would have been taken into account and based on that, the opposite party number 3 ought to have been declared ineligible by applying clause 1.2.7 of the RFP document for the reason that admittedly an order of stay passed by the High Court of Karnataka is operating. So stop. There is no gainsaying that by operation of the interim order passed by the High Court of Karnataka, the order of blacklisting has become ineffective till the same is modified or vacated.
Yeah, please, Padava.
Oh, stop. On the date of submission of bids, as also on the date of evaluation of the technical bid, the interim order of stay was in operation. So stop. The interim order of stay of the Karnataka High Court is still not in operation. So stop. In such view of the matter, opposite party number 3 cannot be said, could not have been declared to be ineligible, invoking clause 1.2.7 of the RFP document. Coming to the plea of suspension as suspension of work as stipulated under clause 1.2.7, no, 1.2.5, it is not, it is apparent from the pleadings and the documents brought on record that the agreement between opposite party number 2 and NHM Meghalaya had ended on 36/2022. Is it correct?
No, thereafter there is an extension.
No, ended. The agreement had ended on 36.
This is the agreement ended 31/3/2021.
31/3/2021.
21. Then 1 year extension, then 3 months extension.
Again 3 months.
Again 3 months extension.
It's ended on when?
31/3/2021.
31/3/2016.
No. Started in 2016. 31/3/2021. Then 1 year extension up to 31/3/22. Then 6 months extension up to 3 months extension up to 30 June 22. Then another 3 months extension.
The agreement had ended
Up to 30th
had
September.
earlier ended, and it was subsequently extended to 36/2022. Stop. Later, thereafter, the agreement was extended for a further period of 3 months. Stop. In the meanwhile, there was a strike called by the field staff on 18/7/2022. Stop. It is clearly mentioned in the closure notice issued by HM, Government of Meghalaya, regarding suspension of the project because of the said circumstance. First off, in our considered view, the plea that the opposite party number 3 suffered any kind of suspension because of the closure notice is not acceptable to us. First off, us sentence four. Any kind of suspension in the nature of quote not having its business activities suspended unquote to attract disqualification under clause 1.2.5 of the RFP is not acceptable to this court. First off, in any view of the further, we are of the considered opinion that the court exercising power of judicial review is not required to interfere in such matters and ought to defer to the discretion of the tender inviting authority, authority which, by reason of having authored the tender documents, are the best placed to interpret their terms. Stop. This court exercising power of judicial review is not, should not sit as courts of appeal. Stop. The scope of judicial review in the matter of award of matter of consideration of tender documents has been dealt with in catena of Supreme Court's decisions laying down the limitations of this court. Stop. We, for the reasons noted above, we are not inclined to interfere. So stop. This application is accordingly dismissed.
Very grateful to your lordship. Just one clarification, if I may, my lord.
Yes.
One clarification. I'm very grateful for the view taken by your lords, of course, by my lords, my lord. My lord, my learned friend's argument that there was a 3-month extension granted last after 30th of June 22 till September is completely without foundation. There is no document to back this. As I had argued before your lordship, my lord, so I strongly, my lord, number one, controvert that. And the reason we were continuing for about a month and a half is because, my lord, on an ad hoc basis, we were told by the Meghalaya government that please carry on till further arrangements are made. So this is wrong to say that there was any final extension up to 30th September. That is without any foundation. And then, my lord, at page 570.
607. I have given the page for 607, that document of 3 months extension. Yesterday also I had shown it.
That is an internal letter.
Now, this is never communicated to me. This is an internal communication. This is an internal communication between your lordship will see mission director NHM.
See, this is unilateral, Mr. I'm recording that. This is decision, this communication is unilateral. They are saying that your term is coming to an end on 36/2022. You are ordered to continue for further periods. Finalization of the.
Can you see the last line?
Yes.
GKB MD is to continue. Providing the services under same terms and conditions for further another period of 3 months.
So it is. Therefore, we are saying.
And this letter.
They could not have commanded. It's unilateral. If we can record that.
In a RFP, that is a that will in RFP it is there. That is how.
You are right. We must record this.
Yes.
He has relied on annexure 10 to the writ application to contain that the term of the agreement was extended beyond for 3 months beyond 36/2022. Stop. The body of the said communication reads and under quote kar dena. Stop. Also, Mr. Mishra and senior counsel has submitted that the term submitted with reference to the said communication dated 36/2022 that the said communication cannot be treated to be an extension of agreement between the opposite party number 3 and National Health Mission Government of Meghalaya for the reason that the opposite party number 3 was asked to ensure continuance of services beyond the period of completion, beyond the stipulated period till quote unquote tender formalities were completed. Tender formality with whom?
Fresh tender to be floated, my lord. So fresh tender formalities. Basically, that's what they meant.
Full stop. It is apparent. He submits that the said communication cannot be treated to be treated to be an extension of agreement. So stop. On careful examination of the communication dated 36/2022, we are of the considered opinion that the same is apparently unilateral issued by the National Health Mission Government of Meghalaya, whereby the opposite party number 3 was asked to continue for further period because the NHM Health Mission had Government of Meghalaya was unable to complete the tender formalities for subsequent period. Stop.
Very grateful to my lordship, deeply grateful to your lordship,
Yes.
deeply grateful, my lord, again.
Matter fixed for 2 p.m. Item number 11.
My lord had heard regarding the.
It will come later. We missed to go through the records.
Notes of submissions are there digitized. At page 13, my notes are there and my friends' notes are there on top of the record from page 1 onwards.
So let it come after holidays. In the meanwhile,
interim order may be extended.
yes. We missed to go through the records. Therefore, we are not in a position to deliver judgment today.
Interim order to continue.
After.
Item 32.
That I have submitted my affidavit with that translated copy of the agreement. Your lordship can here the challenge to the order I have already submitted before your lordship. Not.
Yes.
The legible copy with the with translation. That the playing करता है. The other side. कौन कुछ?
On behalf of Mr. Dare, he is on his leg. Will come.
Who?
Mr. Dare.
Mr. Dale, the counsel for the opposite.
Very tough opponent.
He just
When? Tomorrow we can take up. Tomorrow, day after tomorrow.
Day after.
Thursday. On behalf of. You are representing whom?
Number 5.
Opposite party 5 mile.
Opposite party number 5.
Respond number 5. That's for opposite party number 5.
The day after tomorrow.
Day after on Thursday.
35. Let at 2 p.m. At 2 p.m.
Wait. WPC EU 63 of 2022 was filed by F12 port managers claiming regularization method initially. Then, while this matter was pending,
Oh, that matter.
a court observation of port managers.
Yes.
Well, I have given a date chart on 28/3/2023, my lord, which may come in handy for your lordship's which I have marked the annexes and the respective pages.
This is date chart or list of chronological events?
List of chronological dates.
Yes.
I'll rely on two things, and another short notes filed recently, my lord. Another short notes synopsis, I will place it later. Well, your lordship sees, my lord, without the details, my lord. Government of India by letter notification dated 20th September 2010 directed creation of post of court manager and allocated funds to each state, including 1630 lakhs rupees for state of Odisha. That is page 37. Page 37 of the writ application. Well, there is no dispute regarding this, my lord. Right. Then, my lord, on 21/7/2011, Government of Odisha in Home Department resolution created 32 posts of court managers for the High Court and subordinate court in the district level on contractual basis. On 8/8/2011, the Honorable High Court of Orissa by memo number 6082 issued advertisement for filling up 32 posts of court managers on contractual basis. Prescribing qualification of diploma in general management with 5 years experience training in system and process management and 5 years experience in IT system management and HR management and financial system management, besides having skill and communication skill and computer skill and communication skill and computer application skill. It was also stipulated that preference will be given to the candidates having experience in the field of law. Then the recruitment, your lordship may keep this column 6, my lord. On 11/2/2012, recruitment test was held, my lord. Then in marking distribution to the application for court recruitment test held at High Court of Orissa. Then the minutes of the meeting for selection of the candidate for the post of managers, and following all norms, my lord, to cut it short, my lord, the court managers were appointed on contractual basis, and they joined the post.
Payment of 45,000.
What are payment? Joined the post, my lord. In 6/3, by letter dated 6/3/2012, that is annexure 4, page 57. Then on 2/5/2012, after they completed the training, my lord, 1 month training, they joined back in the different post. They underwent a training of 1 month in the Judicial Academy. Then these duties of the court managers, High Court managers, infrastructure development, these were processed. Then on came the 31/5/2013 and meeting of all the law and home secretary and finance secretaries of all states were held by the Government of India, wherein it was recorded that court managers are very successful, so far as Odisha is concerned, are very successful and should continue beyond the 13th Finance Commission. That is page 72. Annexure 7, page 2. Begins page 72, 73. 74 is the exact.
Mr. Mohanty, was there any selection procedure?
Yes, yes.
No. Later, the result of, come to item number 52 of your date chart.
Subsequently.
Yes, ma'am.
So you had participated in this 50,
Yes, ma'am.
51,
That was by virtue of a interim direction, my lord, that without prejudice to our claim of regularization will be passed. So that principle of estoppel, I don't think would be attracted in this case because it was by virtue of a judicial order of this one report. But the main contention is that the Honorable Apex Court has directed.
That we have seen.
That your lordship has seen. I am only telling that your lordship may kindly see, look at page 77. So far as Odisha, column 12 is the Odisha. Court managers are very successful and should continue beyond the 13th Finance Commission. Then we'll order. Then Government of India also issued letter on 2/12/2014 that due to non-award of funds for court managers beyond 13th Finance Commission period, it will not be possible
So,
to
Mr.
continue.
Mohanty, you are challenging virus of the rules.
I am challenging, so far as I am challenging, Lord, that in view of the Supreme Court's direction, that all existing court managers as on the date of the passing of the order should be regularized. There was no occasion to insert Rule 6 prescribing another test so far as absorption of the virus of the rule, so far as Rule 6 is concerned. So far as absorption of those court managers, requiring them to undergo another test, another interview, another test, another advertisement, that was not required. Because Supreme Court directive was crystal clear that all existing court managers as on that date should be observed. And in fact, this order has been given effect to by various high courts and in different states. And I have given those judgments. I have given also a chart on Annexure A series.
Uh,
22/7/2024, along with a short note of submission. You may kindly have a glance to that Annexure A.
Annexure A of what?
Annexure A series to that short note that I have submitted on 22/7/2024. As your lord, court record. That's hanging Annexure A.
So why was the Supreme Court's direction ignored while?
I don't know.
No, you might saying simply I don't know is one thing, and
my submission is that it was really not necessary. That I would Justice Sathanga Milla.
Yes, which page?
Milord, first serial I have given that Supreme Court's order, Milord, page 357, Milord. 357 of Code file 357. Para 12:9. It is page 14. In this annexure A, page 14, Milord. Para 12:9. As your lordship got it. Para 9 last one. This page 14 of that annexure A. I would Justice Sathanga.
Page again, please.
Page 14 of that annexure A. That bunch of documents.
Yes.
Paragraph last lines, the paragraph 12:9. The services of any person, has your lordship got it?
Yes.
Already working as a court manager in any district should be regularized by the state government, as we are considered view that their assistance is needed for a proper administrative setup. Then, Lord, Chhattisgarh High Court, page 17, Lord, one-time absorption.
This is part of what?
Hello. This is a part of the record, my lord. For convenience sake, I have given this separately so that your lordship needn't go to that 300, 400 pages. Page 17. The services of following 9 court managers presently employed are observed on the establishment of the High Court as a one-time measure in level 2 of pay scale of such and such.
Where are reading?
Well, page 17 of that.
The thing, Chhattisgarh. But the direction is only at Roman 9. Direction is in the paragraph Roman 9 at page 14.
As your lordship is holding page 14. Page 14, paragraph 12:9, my lord. Last line, the services of any person who is a court manager in any district should be regularized by the state government as well of the considered view that their assistance is needed for a proper administrative setup. After this, my lord, on 18th May 2018,
Chhattisgarh might have done that.
Chhattisgarh did it. Then I am showing, my lord, different high courts, not only
Might have all the high courts might have done that. We are just trying to understand that why, despite the Supreme Court's order, who is appearing? High Court, someone is appearing.
Yes.
So this is the only point, Mr. Monty, nothing else.
Yes.
That you were appointed after following a process of selection.
And this High Court again and again recommended to the state government to regularize their services, and also held, when in those recommendations they told that they are working very successfully and to the satisfaction of all concerned. Then
see, there are two aspects.
Yes.
The Supreme Court says that all the persons working managers should be regularized.
Yes.
According to you, this means that all the persons,
those who are existing as on that day,
were bound to be regularized.
Yes.
Irrespective of shall. Just a minute. Shall have to be regularized despite anything. their efficiency, their age.
Their efficiency was once tested. And I have given on record when demonstrate from the record.
All right.
That
When you are challenging
yes.
Rule 6,
yes,
you are challenging that on what basis?
I am challenging on two counts. One, the Supreme Court directive will be treated to be a law, so far as this lease is concerned. And after the Supreme Court's directive, there was no scope on the part of the state government to frame another.
Mr. Monti, you can keep in mind two aspects. One, that there is no law laid down by the Supreme Court. This is a direction.
Direction.
All right. So this direction, according to you, that rule is contrary to the direction issued by the Supreme
Yes,
Court.
yes.
This is one.
Yes.
All right.
Yes. Obliged.
And secondly, when you say that when a process of selection was already undertaken, there was no requirement of incorporating, that cannot be accepted for the reason that the initial appointment selection process was undertaken for appointment on contractual basis. Now it is a regular appointment. So for the purpose of regular appointment, if a rule is framed that a fresh selection process shall be undertaken, there is nothing wrong in it. So independent of this direction, possibly you don't have any argument. Your argument, you may confine your argument and we shall consider that.
One advertisement was there for system officers and others also. They are all regularized without any test.
That is different. You see, they were a different class. You can say that, see, the court or the courts, these system officers were also appointed on that basis and they were subsequently
regularized.
The same policy has not been
followed.
Not followed. But in your case, rules were framed. The statutory rules were framed. So unless you overcome,
subsequently rules were also framed for them, but
without any
without any recruitment test, it was stipulated that will be straightaway observed.
So see, if there are two rules and challenge one rule, that it is.
I am only telling that in pursuance of one advertisement, two sets of personnel were engaged. The written test was conducted, bias test was conducted, markings was prescribed, a committee of judges.
Mr. Mohanty, you can challenge a decision on the ground of it being arbitrary or violative of any constitutional provision.
Yes.
But if that decision is in accordance with a statutory provision, all right, then unless you successfully assail the statutory provision, you cannot challenge the decision.
Then I will come to that, my lord. The same thing happened in other places also. There were rules, they were asked to go for the recruitment test. Some of them were removed. They filed cases in different high court. I don't think those decisions are binding on your lordship for a minute, but they may have a persuasive value on your lordship. Then on the basis of the, at least Kerala, Telangana, these high courts have directed that they should be reinstated and they should be regularized in pursuance of the directive of the Supreme Court. And
so whether in those cases
rule was there.
Rules were framed.
Yes.
Rules were framed.
Yes.
Respective of rules.
Have you stated?
Well,
have you stated that in those cases rules were framed
yes,
and Dihor?
Yes, I have given those judgments.
Where is that?
No, rules were there, but Dihor's the rules, they were appointed.
No.
Then? In the other
they were initially, all throughout India, they were appointed on contractual basis.
Yes.
By following the recruitment procedure. Then, the Supreme Court direction. Then rules were framed by certain high court.
Yes.
and certain high courts directly regularize. In some of the high courts, my lord, subsequent to framing of the rules, certain persons didn't qualify in the test, they were removed. They approached the Supreme Court asked them to approach the High Court first. They came to the High Court. In some of the High Courts, those termination orders were set aside. They were directed to be reinstated. And in some of the courts, certain High Court held that there is no necessity for them to appoint facing through that rule will be applicable to subsequent appointment, so regularize them directed. Those judgment I have given. That apart, we have also challenged that the rules which prescribe the modalities for the is arbitrary in as long as it has given 40% to the virus test. But that will be contrary to some of the decision of the apex court, that large number of marks should not be given to in the virus test. That I will place those judgments. Then Guwahati High Court, my lord, they were regularized the existing
Mr. Monty, we are not concerned with the administrative decisions which were taken by different high courts in the light of the Supreme Court's decision. Because here the situation is different. Supreme Court decision was there, and after that, what is the date of the Supreme Court's decision? 2018.
Yes. 2018.
2/8/2018. 2018. And after 2018, the High Court framed rules.
Yes.
So High Court framed framed rules.
Yes.
And whether such rules were framed in other high courts also.
Yes, sir.
And despite the High Court, there are decisions that despite the High Court rules, their services should be regularized.
Yes, sir.
Not administrative, judicial.
Page 49 of that Kerala High Court.
How many posts are there?
32 posts.
There were 32 posts.
But now 30 court managers.
30 court managers, High Court.
Total 32 posts.
There are now 30
court managers.
There are 30 court managers now at present throughout Orissa.
I will be appearing for some of the petitioners. I'll be trying to assist my.
No, but are you working?
No, that's what. In fact, in addition to my learned senior,
you are not working since when?
22.
38/2022.
Where is that order of Kerala High Court?
That is page 49 of that annexure A.
What is the which is the internal page?
Internal page. Page 49. Page 49 of that.
Internal page.
And this is A series, page 49.
14 is end of some decision.
No, the judgment there. Where is which is the internal page? The judgment there with us.
It starts at page 30.
Continuing Annex A series, continuing page
Mr.
40.
Counsel, what is the internal page of that judgment? Internal
12.
page means the
Page
page number of the judgment.
Page 13. Page 13 of the judgment.
Then there was a read the bill. Then Kerala High Court, there is a read the bill.
Page 96.
Yes. From Kerala High Court. Then Kerala High Court, against this, there was a read appeal, my lord. The read appeal judgment I was also given, my lord. That is then, it begins with page. That read appeal begins with page 64, my lord. And relevant paragraph is not last line, the last paragraph, page 96.
Page?
Kerala High Court begins, the judgment begins in
What
page
is the
64.
internal? What has the Kerala High Court held?
Well, they know that in terms of the Supreme Court.
So where is that?
Page 96. Page 96.
Okay.
Page 96.
Page 96. Prior to it,
There are two aspects, Mr. Mohanty, we are not able to understand. Whether in Kerala rules were framed.
Yes.
And despite those rules, the regularizations were directed to be met. These are two questions, very simple. We are trying to understand. It is not that we are bound to follow what has been held in Kerala. But
no. I am telling you, Lord. Your Lord, you will see page 20, internal page 20 of the judgment. Counsel for the appellant has submitted a tabular column.
That is submission. Where is the...
Lord, I am telling, Lord, this is the counsel has your Lord got it, Lord?
Yes.
Let me place it. Counsel for the appellant has submitted which shows the rules and relevant aspect of government notification and amendment rules of various high courts in relation to the regulation of the court managers of the High Court and that of district judicial. Then government notification relevant rules now for observation. Then says
Odisha government notification is also there.
Oh, Mr. Mohanty, we are not finding.
In Kerala, probably in Kerala, what happened? The rules come cited that without framing a rules, they cannot be observed. Those persons, those who are appointed, straightway approach the High Court, saying that in terms of the Honorable Supreme Court's order.
Mr. The simple question is that if there is a rule and that is statutory, then that is binding.
I got your
And
point.
if we have to take a decision
Yes.
contrary to the rules, then we will have to first declare that rule ultra vires.
In my endeavor, but in my, so far as my, I'll try to overcome the rules.
All right, we'll see.
That I'll see. That I'll try to overcome the rules.
See, let us be clear on this.
Rules committee.
rules committee मना कर देला बेटी से high court गले then they approached the Supreme Court directed them to come to the High Court for regulation on the basis of the direction. Then the Kerala High Court.
See, can a regularization be ordered against the provisions of statute?
Like statute came later on the date of the direction. There was no.
Even if the statute came later, and that statute was contrary to the Supreme Court's direction, even then the statute will have to be declared ultra vires.
I filed this case before the statute came. I understand, my lord. Your lordship is telling that unless your lordship declares Rule 6 to be ultra vires, how can your lordship direct regularization?
That is the and you have challenged the virus also.
Yes.
You have challenged the virus, but you have challenged the virus on 2 counts. They have repeatedly, I am again repeating the same. We have challenged the virus on 2 counts. One, that it is contrary to the direction issued by the Supreme Court, and 2, it is violative of no, there was no requirement of prescribing another test, another selection test, because they had already participated. Second aspect, we can reject straightway. Second aspect, we cannot entertain. First aspect, we'll see. Because second aspect, always a selection test can be held for regular appointment.
So
that is the only.
Yes, ma'am.
I think, Mr. Mahanti, page 44, like, however, no orders were passed on the request for regularization. Further proposals were submitted by the High Court for amending the Kerala Judicial Ministerial Service rules to include the post of court managers in the district court.
Yes.
However, by Exhibit P11, the government ordered the regularization of existing incumbents cannot be allowed in view of the judgment. That was different. They wanted rules to regularize them, but the government refused. Thereafter, the High Court has said that in view of the directions of the Supreme Court, that order cannot be a stand, and that is set aside. So the facts are slightly different. Their rules are not there. They wanted rules for regularization.
The rules committee didn't frame rules. They came against the decision of the rules committee there.
Rules in their favor. So that was not done. So that they challenged, and the High Court said that in view of the direction of the Supreme Court, these orders after to that order
and you regularize them.
That is slightly different. Here we have rules which are, you are agreed by. There they wanted rules which would help them.
They have also taken a stand. Odisha High Court has framed a rule that has been reflected in that document. Para 81. Page 81. Para 41.
That was slightly different.
Already we are hearing data. Here it will take time.
I'll also come with the convenience compilation. So far as me it's concerned, I'll have a very limited point.
Mr. Mohanty, now the points have crystallized.
Is that yes, no. That Telangana High Court, there is a rule, Mila.
Kerala High Court, you've given us 2 judgments.
Mala?
2 judgments you've given us. That is why probably
one is in read, another is read appeal.
Two division benches, Mr.
I want to, my Lord Chief Justice is asking me that whether there is any rules in anywhere in any state that has been discussed.
Simple logic. simple logic that if there is a rule,
Yes,
then
sir.
that has, and if that has force of law, that is binding. Unless that rule is held to be illegal.
Then they did not have rules,
Yes.
they wanted rules.
I'll try to get over that. I'll have my submission, my lord. But you may take it up on another. Sorry.
2010. हाँ हाँ I'll come better prepared. No, I'll come. Now that it has been tested,
Either the rule is to be followed or the rule is to be avoided. So my learned senior Mr. Mahanti on the question of rule to be followed, not by ultra vires, I'll have my
no,
stand.
I say that first proposition is that in view of the direction of the Supreme Court,
The rule is
and
not required.
also in view of the fact that we have completed 10 years of service on contractual basis, we should be regularized.
Cannot be avoided for the reason that rules were framed despite the order of.
But rules, I say, will not be applicable to us. That I'll say, because there are three things. One, regularization. Two, disengagement. Three, wires. We can't seek regularization until we are in the job. If your lordship holds is wrong or illegal, then we'll back to the service, then regulation question will come. Question of wires of the rules, we will say, I'll say that rule is not applicable to us. Straight away, my lord, there are only three documents I'll show, and your lordship, I think, I believe I can approach my lord's consent. Yes.
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 It has to be decided because
Yes.
this is within the knowledge of the Chief Justice that the post have been advertised.
Yes.
How was it? Yeah,
dictation
And how do you know that all of them are? Just give us a clear date.
The lordship will like to hear it before vacation, sometime 7th or 8th. Or if it is after vacation, then as your lordship pleases.
7th we can try.
7th will do.
7th Saptami.
The senior is saying that
after 22nd.
Your lordship, can it be anywhere on
22nd.
First, third, fourth?
22nd.
22nd will do. At the same slot. Same 2 p.m.
Please just come, address us on the points.
Okay.
And Mr. Putia, you are appearing for the. That is the only question.
Yes, my lord.
And you will have to tell us why, despite the order of that direction of the Supreme Court, that is not a judgment, that is not laid on a law. But despite that's a direction. 142. Despite that direction, the High Court framed the rules. Yes.
Short note short note.
Item 47.
My lord, your lordship will remember that case where there was two conditions, my lord, to refresh your lordship's memory, my lord. Now they have filed a counter admitting that inadvertently they uploaded those clauses.
Yes.
Railway Lord issued a request for proposal for execution of work relating to Talchel Bimla BG Rail Link project.
All right, what is their stand now?
Now their stand is that it has been that clause has been uploaded. Therefore, this confusion.
But admittedly, there is a inherently it was made. I agree with my grand senior. But facts remain that this agreement is consequential to the EPC. That is, this full form is engineering, procurement, and construction EPC mode. That is a part of the agreement. There is effect from 28/5/2020. And basing on that mode, if suppose a person has taken a contract for 1 lakh and he has quoted 70,000 as a lowest bidder, we have given to the work. Suppose he has paid away, then we'll know. So this clause, as per the EPC, this clause has been inserted in the agreement that suppose any malpractice is done, then this amount which is as a security, that will be adjusted. This is the motto of the contract. Here is the case. What happened? There are two things. One, that is clause 2.21.
Have you filed your affidavit?
Yes, we have filed the affidavit. We have taken that specific stand in this regard.
Do you want to file a reply? Not required.
This is the only point, Mila.
All right. We have to complete a judgment. We will begin a judgment. We have fixed time at 3:30.
But it will not take more than.
So we can take up the matter on Thursday.
All right.
Thursday we will.
Can it be Monday? Tomorrow I'll be there. Another 2 days I'll be there.
Monday at 2 p.m.
Because other penalty expert, that's why I'm facing problems.
Item 49.
Interim order to continue.
49.
68A matters, the GST Act notes. And your lordship said that directed the CGST authorities because a particular agreement was made that this notification of 56 was not passed by the GST Council. There, your lordship had directed my learned friend not to file an affidavit. My learned friend has filed an affidavit. So in the affidavit, it emanates that it's a law committee recommended, since the GST council has sat on that particular event. So the law, on the recommendation of the law committee, this notification 56. As my learned senior, Mr. Sridharan was also arguing.
You can do one thing. We are dictating a judgment. If it takes half an hour, then at 4 we can take up your matter, because it has become very short. The point has, yes, Mr. Sridharan.
There is a learned single judge of the Gujarat Guwahati High Court has decided this very point. Third extension is invalid. But the learned single judge of lordship is not binding on your lordships. I can place only.
So we have the point we had formulated.
Lordship. And therefore, if my learned friend on the other side wants to look into the judgment of the Guwahati High Court, because it concludes this point clearly and analyze it in detailed reasons, your lordship.
So we can take up on Thursday.
Whatever is convenient to my other side.
Yes,
in fact, the Guwahati High Court.
For us, not post pujas would be convenient, subject to your lordship's.
Your lordship, post puja.
Because there is no issue.
Your lordship,
to be decided.
In fact, that will cover 18, 19, and 19.
In fact, some issue, your lordship, pursuant to your lordship's direction.
Yes.
We have sought for instruction from the council through our policy wing, your lordship. And council, your lordship, CBIC so far has issued a letter in the July 2020. In that letter, they have clarified that in the 53rd meeting, your lordship, that has been ratified. So as per section 168A2, it could have been issued retrospectively, your lordship. So only that part, only 53rd your lordship council meeting, we are awaiting the response of the GST council so far as the minutes of 53rd meeting.
Therefore, it should be taken up before that meeting is held.
No, meeting has already held. 54 meeting has already been concluded. So 54 meeting has already been concluded.
They replied to us under RTI. We asked for RTI.
I'm putting this letter to your lordship.
It come on Thursday.
Lordship, apart from this letter, I have to develop this issue, some likely different so far as the Assam High Court has passed the judgment. Their issue is squarely applicable to us and partly is different. So state has not accepted the view of the no notification has been there. That is two issues. So I try to develop the case so far as in view of the.
We will hear it on. Hear it on Thursday. And if required, we shall adjourn. Otherwise, we will decide on Thursday.
Yes.
Question arises, Millers, to my humble opinion, whether the defect is now they have on their own admitted recommendation.
No. I have not said so. I have
Your
not
affidavit said so.
No, I have not. I have never said so.
Whether
You
it is
cannot
curable,
argue amongst yourselves.
whether it's curable or non-curable.
That I have to satisfy. That I have to satisfy.
We will.
So may I pray?
See, yes, we have duty to decide whatever you contend. So we will decide. Decide Thursday.
My friends are all suggesting for post vacation.
Let it come on Thursday.
Let it, yes, please. Absolutely.
Interim order.
Interim order.
Yes.
So same time, two time.
Yes.
Obligement.
May I pray for one thing, my lord? Item 14 of today's list, my lord. Similar interim orders, my lord.
Yes, the same matters. 168.
168. Item 14.
3 matters.
Okay.
There are no interim orders there. You want interim order?
Fresh matter.
Yes,
Fresh matter.
fresh matters. Item 14 of today's list.
Item number 38, 64330.
Yes, Farah, please take your seat, madam. Want to say something? Based on the submissions which have been advanced on behalf of the parties. Questions of seminal importance emerge. To test the sustainability of the impugned judgment passed by the learned single judge. The questions are following as 1. Whether the advertisement issued under the signature of the Deputy Director of Agriculture for the districts of Bolangir and Keonjhar can be said to be incompetent and illegal on the ground that it was the same were issued in breach of Rule 5.5 of the 1981 rules, which stipulates that such advertisements should be published by the Director of Agriculture and Food Production. So stop. This question has to be dealt with in the background of the admitted fact that the office of that the Director of Agriculture had requested the Deputy Director of Agriculture, Directors of Agriculture, Bolangir and Keonjhar, to publish the said advertisements comma, fixing a recruitment schedule, comma, through a communication dated 13/9/2013. So stop. It is the case of the petitioners that the said advertisement was merely published under the signature of the deputy director as requested by the director of agriculture, and therefore the deputy director acted as a delegate of the power vested under the office of the director under Rule 5, bracketed 5 of the rules. So stop. Two. Whether the advertisements can be termed as illegal on reasoning that despite a direction issued by this court for issuance of a corrigendum, comma, a fresh advertisement was issued, comma, denying thus an opportunity to those who had applied in the first advertisement and became overage in the meanwhile. So stop. Whether the third, there was no plea taken about the authority of the issuing deputy director.
Competence, yes.
No plea
No
taken.
pleading, there was no pleading at all.
No written plea, yes. No written submission.
Only
Yes.
do the course of argument. This is the-
We placed our submission in that regard.
All right. Next. Adverting to the question number 1 as set out, there is no dispute over the factual aspect. There is no dispute about the fact that no plea was taken by the writ petitioners who were applicants before the Odisha Administrative Tribunal, that the advertisement was illegal because the same was issued by an officer who was not competent to issue. First off, we need to keep in mind that the advertisements were challenged before Odisha Administrative Tribunal in those who were transferred
Yes, pregnancy of 2013.
in 2013. So stop. In the original applications filed before the tribunal, no such ground was taken. So stop. The original applications were transferred to this court after abolition of the tribunal in the year 2014.
19.
2019. In the year 2019. There is absolutely no, from the pleadings on record, it does not appear that any such stand was taken on behalf of the petitioner in the transferred writ petitions, questioning the legality of the advertisement on the ground that the same were issued by a person not competent to issue in terms of Rule 5.5. So stop. It has been argued argued by Mr. J.K. Rath, learned senior counsel, that though the said plea was not taken in the pleadings, the same being question of law was rightly raised during the course of hearing before the learned single judge. That has rightly been considered by the learned single judge. This is what you wanted to say, Mr. Rath. This is what you wanted to say.
Yes, yes.
All right. Mr. In our considered view, it has been rightly argued on behalf of the petitioners that the deputy directors of deputy director agriculture, directors of agriculture, Bolangir and Kanjhar, got the advertisements published at the request of the director, who is the competent authority to publish and thus, they acted as delegates of the powers conferred, powers vested in the director agriculture.
Pardon.
Reliance has rightly been placed on the Supreme Court's decisions in case of PK Roy, Union of India and another versus PK Roy, bracketed AIR 1968 SC 850, wherein the Supreme Court where is that proportion?
10, the facts are discussed.
No, where is the ratio?
Para 11 towards the middle. It is, the maxim is given in italicized portion. That would be page 11 of that Xerox copy which we have given. On top, the page number is there. And my lord would see that italicized portion, the principle of the maxim delegates non-protest delegate. The maxim deals with extent of statutory authority and permit.
Does not apply over there.
Yes, it is true that the delegation in grievances does not imply parting of statutory powers. And then below that, does not apply. Then next page, they have quoted
which
Pradvat Kumar Bose versus Honorable Chief Justice of Calcutta High Court. Para 11 has the entire ratio.
No, paragraph 11 is long.
Yes.
This decision is on the point as to which powers cannot be delegated. Like if an authority has to exercise power, so that power he cannot delegate. So that is to be exercised by him only. So this is what the Supreme Court lays down in this case.
Then, as pointed out by the House of Lords and Board of Education versus Rice, a functionary who has to decide an administrative matter of the nature involved in the case can obtain the material on which he is to act in such manner as may be feasible and convenient, provided only the affected party has a fair opportunity to correct. So, and so the same principles reiterated in Chancellor. Then that quotation has that volume of work, it would impair efficiency. So last 3-4 sub paragraphs of para 11 would have the ratio.
See, when it refers to Calcutta High Court decision, it says what cannot be delegated except where the law specifically so provides is ultimate responsibility of exercise of such power.
Then below that, local government board versus Aldridge in the following passage. The volume of work entrusted to him is very great, and he cannot do bulk of it himself. He is expected to obtain his materials vicariously through his officials, and he has discharged his duty if he sees that they obtain these materials for him properly.
This in case of Siddharth Sarangi versus Board of Trustees for the Court of Calcutta and others, reported in 2014, volume 16, SCC 248. Yeah.
Exact portion, if your lordship want, it would be paragraph 5 and 7.
5 and 7?
Yes. Para 5 discusses about these modern day developments. And this essential function is in para 5.
Which paragraph? Paragraph 5 and?
Paragraph 5 and 7. 5 discusses about the complexity of modern day administration.
Paragraph 7.
5 and 7.
Paragraph 7 of which?
Of this, I'm holding the SCC.
Paragraph
2014.
7 of which reads thus. First off, in case of Siddharth Sarangi, bracketed supra, the Supreme Court has elaborately dealt with the settled decision, the delegation of legislative powers and delegation of non-legislative / administrative powers. Full stop. The court ruled that a legislature cannot delegate essential legislative functions which consist in determination or choosing of the legislative policy and formally enacting that policy into a binding rule of conduct. As regards delegation of non-legislative / administrative powers, the Supreme Court held in paragraph 5 as under. Stop. The in the case of Siddharth Sarangi, issue related determination of lease granted by the Calcutta Port Trust to the petitioners of that case. First off, in the said case, an ejectment notice was issued by the land manager on the ground that it was illegal and without jurisdiction, he being not competent to issue such ejectment notices. First off, the Supreme Court, after having examined the provisions of the Major Port Trusts Act 1963, held in paragraph 17 that the chairman having duly authorized the land manager that since the chairman had duly authorized the land manager, it could not be said that the ejectment notice issued by the land manager was without jurisdiction. So stop. In the present case, we are of the view in the present case that issuance or publication of advertisement is not advertisement under bracketed 5 or some rule bracketed 5 of the rules is purely administrative in nature and we do not find any illegality in publication of the advertisements by the deputy under the signature of Deputy Director Agriculture, the appointing authority, bracket authority, within bracket, on a request made by the Director, Agriculture. So stop. Publication of advertisement is not a power vested in the Director under Rule 5.5 of the rules. Rather, it is one of the functions for initiation of selection process. So stop. We do not find any such legal infirmity in publication of the advertisement under the signature of the Deputy Director in the background of the facts noted above, as it would have the consequence of the entire selection process being held illegal. So stop. Illegal. This is more so because the Director is admittedly the appointing authority for the post of VAW under the rules. So stop. In such circumstance, in such circumstance, the reason assigned by the learned single judge for interfering with the impugned judgment, impugned selection, assigned by the learned single judge in the impugned judgment for interfering with the process of selection cannot be sustained. So stop. Next. The second question as to whether it is obligatory for the competent authority to issue a corrigendum to the first advertisement corrigendum and a fresh advertisement deserved to be interfered with on that ground alone. Deserves to be addressed in the background of the fact that the second advertisement was not interfered with on this ground. Mr. Mishra, are we correct? The second advertisement was not interfered with on the ground that it was a fresh advertisement. It was a fresh advertisement and not a corrigendum.
Yes.
The second advertisement was caused because it did not stipulate the requisite conditions.
Yes.
Educational qualification.
Lordship is right.
Your lordship is right.
This
Are we correct?
Yes, yes.
Are we correct? The second advertisement was not caused on the ground that press advertisement was issued instead of corrigendum.
Minus because the second advertisement was also not carrying the quality.
Exactly. This is what for the addressed in the background of the fact that the second advertisement, which was also fresh advertisement, comma, instead of corrigendum, was not interfered with by this division bench, by a coordinate bench of this court, on the ground that the authority ought to have issued a corrigendum instead of fresh advertisement. So stop. The second advertisement was interfered with on the ground that the qualification which was required to be stipulated in the first advertisement was not mentioned in the second advertisement also. So stop. The plea at the subsequent plea of the applicants oblique petitioners, that issuance of fresh advertisement in place of issuance of corrigendum defeated their right to be considered because they became overaged in the meanwhile, could not have been sustained by the learned single judge. So, anything? If I find some judgment is to be added, I can add that. We can add that. We can find it. It is worthwhile mentioning at this juncture that the selection processes were conducted in the year 2013.
Yes.
And based on which the appellants have been appointed and presently working on regular basis.
Yes.
A regular basis in the Department of Agriculture since 2013.
14.
Since 2014. Stop. There is no allegation of any irregularity, bias or maybe in the process of selection. Stop. process of selection.
So far the one objective also. So far the relaxation prayer was.
On the point in relation to such applicants slash petitioners who claimed to have become overage because of subsequent advertisement, this court by order dated, can you refer to that? That has been noted. By order dated 3/2/2012 had permitted them to make representations for relaxation. So stop. Their claims, their representation for relaxation in age has been rejected by the competent authority. So stop. On 25 October 2013. So stop. It is not in dispute that the persons who had become overage had sought for relaxation. Of a relaxation in age criteria, mainly on the ground that the selection process for the posts in question had not been undertaken for several years. That was the ground.
17 years, they say.
That was the ground for relaxation. Several years. So stop. The respondents slash writ petitioners have not been able to make out a case that they had any right of age relaxation in accordance with any statutory rule or under any other provision having force of law. So stop. The aspect of age relaxation has not been accepted by the as there is no finding on the said point. So stop. The writ petitioners have not questioned the decision of the learned single judge in not addressing the issue of relaxation of age. No writ appeal is fine?
The writ appeals are there, but they have not been listed.
They have not taken it. Just
They filed, but
you are not as part of the date advertisement, and therefore, my lords, we had applied for selection. That advertisement was not taken into consideration by the authority. The next advertisement was passed. Therefore, my lords, we are continuing. Our application is continuing as per 2008 advertisement all through.
All right. Apart from, as regards age relaxation, it is also the as has been noted above, the case of private contesting respondents / writ petitioners, that some of them were qualified in terms of age when the first advertisement was issued, and they stood disqualified for the last advertisement based on which the selection process was undertaken and finally undertaken, and the appellants were appointed.
It is for Bolangir district, my lord, only. Keonjhar,
In
we are
relation
within the age.
to Bolangir.
Within the age.
So stop. Next. As regards the writ petitioners / respondents in the present appeal, you had participated?
Yes.
They had participated in the process of selection.
We have applied for other district, my lord, and that was been rejected on overage in 2013. In 2012.
No, what happened to Keonjhar?
Keonjhar, I am saying, well, I have not. We are not selected for Keonjhar, but this is was the terms of that we can.
What happened? Whether you have participated in Keonjhar or not?
No, I am not participated for Keonjhar district.
Had you applied?
My lord, that is not for Keonjhar. That I have taken. That employment.
We are dealing with only two districts, Keonjhar and Bolangir.
My lord, my application, our application been rejected by the authority because of we are overaged in 2013, not in 2012. But we are SCBC candidate, we should get 3 years relaxation, so we are within the age at that point of time.
They had participated in the selection of Keonjhar, but that is available in record. I had different lawsuits also.
But you had participated in Keonjhar. Keonjhar, you had participated.
They have stated to me that I have applied, my lord. Our application been rejected as overage in 2013, the last advertisement. Then thereafter they have been included or whatever that I don't have any instruction on that.
My lord, the other day I had given their copies of their application form in pursuance of the last selection of last advertisement of 2013, which were received. And my lord, on record at page number 117 of this WA number 29023, in the list of SCBC male valid candidatures, names of the petitioners do find place.
Don't point out figures to her.
No, I'm saying, no, sorry. I am extremely sorry, my lord. I'm extremely sorry. So they had, my learned friend is not accepting for the reasons best known to her, but fact remains these are the applications and they have participated. And all the 4 applications, they were participated. They were also They were also the petitioners in the second round of litigation where their cases are found to be within age. That is why they were excluded from the purview of that direction given in paragraph 9 to make their applications. So they are the very same petitioners in the second round of litigation, and your lordship have also examined the said factum on the last.
There is no interview. There is only mark based. So we have participated means we have applied and they have rejected on the ground of you are overage. Is there any written examination or interview or anything?
Only the basis of marks.
Only basis of marks.
Respondents in respect of Keonjhar district had participated in the process of selection. They have been found to be less meritorious than those selected. Stop. Next. In such view of the matter, we are constrained to interfere with the impugned judgment of the learned single judge. So and so set aside, allowed, no order as to cause. Anything else?
No.
Okay. Just a minute. We want some clarification.
5 lakhs also only cost.
Appearing for the respondents.
May I one thing? Let there be huge vacancies available. Government consider our case.
As
After
there
being
are.
prolonged fighting before this honorable court from 2008, 12, 13, and government is at fault, not complying the orders of this honorable court, not issuing corrigendum. Let government to be considered, my lord, at least that much. Because we are,
Let it be decided somewhere else.
my lord, well, let government decide whether we can be adjusted.
We cannot do anything. We are just considering it will be open
My
for
lord.
the,
Obliged.
it will open for the writ petitioners as contesting respondents to approach authorities for authorities to consider their cases for engagement against the post of BLWs if the posts are vacant, keeping in mind the fact that they had been pursuing their legal remedies before the tribunal / court for more than a decade.
In the meantime, that rule has been changed. Another rule has come into force.
They have been protected.
Relaxation,
They are-
something, some policy decision they may take, they may not.
Yes.
Read petitioners.
Please inquire. Please, there is some.
11 appeals. So WA 2910 of 2023, there are 3 private respondents. So Mr. J.K. Rath is appearing. Writ appeal 2910 of 2023.
There were the respondents.
So respondents 4 to 6, you are appearing. Then writ appeal 2888 of 2023. Appearing for respondent 5. Respondent 4 has died probably. Okay. Then writ appeal 29 of 2023.
She is
I'm appearing. So respondent private, respondent 4 persons are there.
Yes, respondent 1 to 4, you are appearing.
Okay. Private individuals.
Same as writ appeal 2907.
Yes.
So you are appearing for the respondents 1 to 4 as well as okay. Then writ appeal 2911 of 2023. Writ appeal 2023. There is 1 private respondent, respondent number 4, Prafula Kumar Purohit. Who is appearing?
I'm appearing. Prafula Purohit, I'm there.
You are there.
I'm there.
All right. With Mr. D.N. Rath.
Yes.
All right. Then writ appeal 2925, Sudhir Sahu. That is also Balangir, I guess. Sudhir Sahu, who is appearing?
The other day, Mr. Giraja Prasanna Das was appearing by giving his memo of appearance.
Memo of appearance.
Name also.
His name also appears in the list.
Where? 2925.
Yes, let's see
The
that.
cause list.
2925, Mr. Vedara Prasandas, Vicky Hati. Yes, that of Orissa response.
Okay.
In all 3 matters, 2940 and 2941, Vedara Prasandas is appeared.
Then 2940 also he is appearing.
Yes.
Yes.
Yesterday he was not there. Today also he is not there.
Last time he was there.
He was there.
All right. Then 8 also he is appearing.
Yes.
Okay. Then WA 2974 of 2023.
Nobody is appearing.
No, Balakrishna Behra is there. Mr. Rath.
Mr. Rath is appearing in other case for that particular respondent.
Mr. Rath.
Sir.
Balakrishna Behra 2974 of 2023. His respondent number 5.
My lord, the number.
Balakrishna Behra.
Balakrishna Behra, who is respondent 5 in the first 2 writ appeals.
Yes.
No, sorry, second writ appeal. You have appeared for him in WA 2888 of 2023. So he is also respondent number 5 in writ bill 2974 of 2023.
My lord, while the name of dear not appears, I am happy in that case.
Name not appear, that's why I'm asking. But the party is the same.
Same person.
Then 2992 of 2023, again Balakrishna Behra.
State appeal. See, can-
Respondent number 2. This is filed by the state.
Yeah.
And respondent 1 is dead. Then last one, madam is appearing.
My lord, 3022.
My lords, may my lords, in item 39, the interim orders may continue.
Well, it's a writ appeal arising out of a service matter. May I just take this matter taken up on 1st at 2 p.m. Why are you seeking a 2 p.m.?
First of
October, my lords, next
Why?
Tuesday. My lords, because this matter was initially remanded by the Honorable Apex Court. And this present appellant is out of service since 1998. And all the parties have appealed this matter can be heard, my lords. Which is why.
we will try, just make a mention on first.
On 1st, my lords. Great.
My lords, just in item 39, the interim orders may continue.
All the today's matters will be
Well,
discussed
I
on
have very
first.
small. I have very small prayer in item number 53, Miller. In that case, petitioner side is present. My learned friend Mr. Jana is there, Miller. Miller, in that case, I am appearing on behalf of the OP number 4 college in which the student concerned, the petitioner is reading and she seeks for transfer to other college, Miller. I was served with the copy of the consolidated writ application yesterday night, Miller. I pray, Miller, any convenient day in the next week. I have already brought to the notice of my
1st October.
Oblige.
In item 39, the interim orders may continue.
All right.
That's obliged.